Hello, everyone, and welcome back. I hope everyone is doing well, and welcome if you are new. Okay, so today we're going to be talking about the preliminary hearing in the Tyler Robinson case, the Charlie Kirk murder case. And it was a fascinating week with all the hearings, and we're just going to kind of do an overview update on that. I'm just going to go over my thoughts, go over what happened, go over the crazy stuff going on around it. Yeah, it's super late, but I wanted to get something out because I do have videos covering this case. And so I wanted to give my thoughts the way that I do. In our meandering journey that we go about things around here. Okay. So let's get into it. So I thought we would first I would say there has been like some confusion on what this even was. And so a lot of people kept calling it a trial. A lot of people, I think, were doing this very disingenuously to manipulate their audience, stir their audience up to be crazy and say crazy things and spread lies maliciously with the coverage of this while it was going on. So, the definition of preliminary hearing. Okay, so let's go over the definition of this, what a preliminary hearing is. And I know that it's odd because it's been 10 months. There still has not been an arraignment. A probable cause hearing normally happens very soon after a person is arrested and charged with charges. There will then have a preliminary hearing or a probable cause hearing or a grand jury will happen before the person is arrested. So it's all just sort of dependent on the state, on the crime, etc., etc. But normally when someone is arrested, they have to show cause to a judge on why they have them. Like, hey, we did this investigation. This is what we have against them. This is why we think that they have done this crime. We are going to bring them up on these charges based on this evidence. And the judge has to look at it and evaluate it and be like, okay, this seems reasonable to move forward. Okay, so but the reason why it's so odd in this case is because of the type of case it is. It is a death penalty case. There is massive amounts of evidence in this case. And so the defense attorneys and the state agreed to push this out like several times. And this is why it has taken this long. Normally you have the probable cause hearing. Very shortly after that, if the judge agrees that the evidence is reasonable, you then have an arraignment hearing where the person pleads guilty or not guilty. So none of that has happened in this case, and that's why it seems so weird, and that's why like 10 months later, people are getting confused thinking this is the trial when it is not. Okay, a preliminary hearing, also called a preliminary examination, preliminary inquiry, or probable cause hearing, is a formal court proceeding in the criminal justice system that occurs after a defendant has been charged, but before a full trial. The main purpose, so the primary goal, is for a judge to determine whether there is sufficient evidence, known as probable cause, to believe that a crime occurred and the defendant committed it. If the judge finds probable cause, the case moves forward to trial, or the defendant is indicted by a grand jury in some jurisdictions. If not, the charges are usually dismissed. The prosecutor typically calls witnesses and introduces evidence. The defense can cross-examine those witnesses and may present limited evidence of its own, but is not required to do so. Defendants frequently waive the right to a preliminary hearing, especially in exchange for concessions or to speed up the process. Now, this is important. So you might have heard attorneys using the term, or you might have heard in court bound over. So that means the case will proceed to trial, like the judge is binding it over, or it's going to be bound over. Those are two different ways of saying it. That means the judge is binding it over to proceed to a trial. Okay, so now another thing that has been going on during this is that people are getting confused about what is allowed in a preliminary hearing. So people all over Twitter and all over YouTube probably and in X Spaces are saying things like the judge is allowing hearsay into a trial, right? He's not getting a fair trial, et cetera, et cetera. And they're like, how can they do that? Blah, blah, blah. Well, when you have a probable cause hearing, you are not following the rules of a trial. The rules of a trial are very different than a probable cause hearing, and you have to prove the case beyond a reasonable doubt is one of the differences. So you don't have to do that in a probable cause hearing. You only have to provide reasonable probable cause, which is a very low standard compared to at a trial. Now, another thing is that the rules of evidence in Utah state that reliable hearsay is allowed. Now, this does not mean they're bringing random people off the street and interviewing them and saying, oh, getting them to say whatever they want. That's not, when people hear hearsay, that's what they're thinking in their minds. But a police report is hearsay. A witness's testimony written down is hearsay. Okay, so the medical examiner's report is hearsay. Now, if they had to bring every single person, the medical examiner, all the police officers involved, all the witnesses that were involved, etc., to a probable cause hearing, then you're just actually having a trial, and all this is a giant waste of time. These people have, this costs a lot of money just to even do the probable cause hearing, but the trial itself, all these people, the medical examiner is getting paid by the state. Their time is, how are they going to be doing medical examinations if not only do they have to show up for trial, but they have to show up for probable cause for every person convicted of, a murder or whatever. And so this is why they allow in probable cause hearings reliable evidence. And that's the stuff that has been collected without having to bring the person in who wrote the report, whatever, to establish foundation like you have to do in a trial. So people are getting very confused about that and saying just the most ridiculous, crazy stuff. But yeah, so let's see. So I hope that makes sense, that this is not a trial. This is probable cause. It happens every day, normally without anybody knowing it. And it normally doesn't take very long, 30 minutes, an hour, whatever. But in this case, it's taking longer. And people also seemed confused about that. So I heard people saying things like, why are they having so much evidence and taking so much time if it's just a probable cause hearing? Why are they providing so much evidence? And I am going to explain that part of it right now. So let me show you. Okay, hopefully you guys can see this, but this is one of the very first documents filed in the case, which is it's labeled as information, but it's basically like one of the first probable cause statements filed. There were two. One written very shortly after that detailed a bunch of stuff, and then this one to detail all the counts he was being charged with. So you have count 1, aggravated murder, and on that count you have victim targeting enhancement. Okay? And you have violent offense committed in the presence of a child, aggravating factor. Okay, count 2, felony discharge of a firearm. And on that one, on count 2, is victim targeting enhancement, violent offense committed in the presence of a child. Count 3, obstruction of justice. So this is concealing the firearm, hiding his clothes, telling Lance to burn a note. Now it seems like he was the one who burnt the note, etc., etc. Count 4, obstruction of justice, So this is another one added because he intended to so one, let's see what's the difference between the two. So this one, the first one is about the firearm. Okay. This second one is about the clothing and the conduct that constitutes as an offense. So, okay, so that's that part. So, firearm, clothing, tampering with a witness. Okay, so that was because of the stuff that he said to his roommate. Okay, count 6, tampering with a witness. Other stuff that he said to his roommate. Count 7, violent offense committed in the presence of a child. Okay. And on that one is also victim targeting harassment. Okay, so in the probable cause hearing, they have to provide evidence for every one of those charges and the aggravating offenses attached to those charges. So that's why it's not just, did he murder Charlie Kirk, the charge of murder? It's all that stuff on there. And so, and they also kind of just have to show what their investigation, like the early parts of their investigation that led to probable cause, which is what is in this document, to the judge. And because there was so much in the beginning part of their investigation, they have to explain all that. So that's why it seems odd. Like, what is going on? Why are they showing so much evidence? Well, that's all the stuff that they kind of did in the very beginning part of the investigation. So it's almost like they're telling the story to the judge of everything that led up to the events after Charlie Kirk was shot. And this is why we're charging him with these exact charges. And the judge has to look at those and say, do these charges and these aggravating offenses tack onto these charges properly and everything. So hopefully that explanation explains why the probable cause hearing was so long and detailed. That's at least one of the reasons. Another reason is that this is a death penalty case. So everything has to be done in a very particular way, because when you're looking at appeals, people who have been, you know, in people who have been convicted of murder and they have the death penalty placed upon them are higher levels in the appeals court, and they're going to look at those way more better at, under a microscope than other cases. So if you've been convicted to death, this is like a higher tier in the appeals courts, and they will appeal no matter what. Perfect trial is ran, they will appeal. And there will always be stuff that they come up with for a reason to appeal. And it's a fascinating part of law, the appeals courts and everything, and the lawyering that goes around that whole thing. But so they have to be extremely careful with how they're doing this, because it is a death penalty case. And the fact that it is a death penalty case just makes this whole process take much longer. It takes forever to work it all out. There's going to be tons and tons and tons of motions and limine, pretrial motion hearings. The state's going to, say we want to admit all this stuff. The defense is going to object to all that. They're going to try to get as much stuff removed as they can from the trial. There's going to be expert witnesses that they are going to go back and forth on as if they can be expert witnesses. And then the state will, or Tyler's defense team will have to ask for more money because they want to do certain testing and they need this certain witness and blah, blah, blah. And so they'll have to have hearings on that. And then they're going to litigate the DNA and they're going to it's just going to be crazy. And I've watched death penalty cases before, and they are wild. It appears to me as if the main goal of death penalty lawyers, because they have to be special lawyers that are certified for death penalty cases, it appears to me that their main goal is just to stall and be the biggest pain in the butt to the state that they can be, so that they get the death penalty off the table, their client survives, and we deal with it in appeals. We get a new trial in appeals if we can, that now has death penalty off the table, right? So that is sort of the strategy that I have noticed with death penalty cases. So it is very possible that this will play out exactly how I've seen it. Like Kohlberger comes to mind. It was like 3 years of just craziness, and then eventually they made a deal with him to plead guilty and got death penalty off the table. And yeah, so okay, now Andrea Burkhart, if you are not following her, whenever anything happens with this case that's in court, she will live stream it and then she will give you a complete breakdown. She is one of the best attorney LawTube people out there. And so if you are not watching her, you need to. Her link will be in the description. But she wrote a really good thread on all of the evidence that was provided by the state. And keep in mind, the judge is required to look at all of the evidence in the best light for the state in a probable cause hearing. Okay, here is my list of the evidence, documentary, and testimonial presented by the state during Tyler Robinson's hearing. Because this is a probable cause hearing where all reasonable inferences from the evidence will be drawn in favor of the state, I have described this evidence consistent with the state's interpretation of it, because that is how the court will consider it for probable cause. Shots heard at 12:23 p.m. on September 10th, 2025. Screwdriver found on Losi Center roof. DNA found on the screwdriver with strong support for inclusion of Tyler Robinson as the major contributor if Lance Twiggs is the minor contributor. Okay, so that was another thing. People were going around all over X and they were saying that the major was Lance. And I'm like, what are they talking about? That is not what they said at all. It was wild. Okay, sniper pad on the roof. And so what that means is that they have pictures and, they took pictures of the spot where he laid prone, and you could see the imprint of his arms. UVU surveillance footage of the person on the roof showing activities at the time of Charlie's murder consistent with a shooter, as well as the person's subsequent flight with something in his hand. Shoe impression at the northeast corner of Losi Center corroborating video. Okay, so we see the video of him jump off the roof. There's the shoe impression, so that is corroborating that. I'm probably not saying that right. Sometimes I can't say words, y'all. Okay, scuffs near northeast corner of Losi Center corroborating video. Medical examiner conclusion that Charlie's cause and manner of death is homicide by gunshot wound. Okay, now we also found out during the testimony that the rifle was manufactured in 1938 and that it had a retrofitted barrel for a 30-06, because that gun didn't have one that was a 30-06, a barrel back then. Now, I was I had no idea it was going where it could have been a surplus. Remember, I made the video where it could have been a surplus, a World War II stock. They had all these guns, people bought them, and then they changed them to sell and be more commercial. So I said it could have been that, or it could have been a Mauser M98 that was manufactured more recently, because they started manufacturing them again at a certain point. Well, now we find out that it definitely was World War II surplus, because if it was made in 1938 and then it also was retrofitted, that is exactly what everyone was doing with those surplus guns. So that answers that question. Okay, bullet jacket fragment and 4 bullet lead fragments recovered during Charlie's autopsy. Jacket measured as consistent with .30 caliber class bullet. So if you remember, the testing that they did was inconclusive to that particular rifle because of the damage of the actual projectile. So the bullet jacket was completely in 2 pieces and really destroyed. And that is what they would have used to match the etches and the striations of that to the gun. So they couldn't rule it out, but they also couldn't rule it in. And there were 5 fragments, or she says 4. I thought I saw 5 in the picture, but we'll go back and we'll check that because we're going to look at some of this stuff in a minute. But I could have swore there were 5 lead fragments and 2 bullet jacket fragments, but maybe I was looking at the picture wrong. But that is how the jacket itself measured as consistent with a .30 caliber class bullet. So that is how they were able to match it to a .36 caliber, well, a .30 caliber class, right? Okay, UVU surveillance footage of 3 additional visits to the campus by the same individual pictured at the time of the shooting, wearing different clothing, visiting amphitheater where shooting occurred, as well as Losi Center. Video surveillance also establishes connection with a gray Dodge Challenger. Ring doorbell footage showing the gray Dodge Challenger parking near campus after midnight on 9/11/25. So this is when he was trying to go back and get the rifle. And I find this really fascinating. Let me get back on screen. Okay, so the details of him trying to get the gun is extremely interesting because we had tiny little bits of fragments at first. Then we got a little bit more of the text messages because when they released the search warrants, they were in there, more of them. But we were all trying to figure out, like, what time was it that he was trying to get this gun? How many attempts was it? Blah, blah, blah. But it was reported that he had contact with a police officer who, because he was trying to go get the gun, police had the place locked down. So a police officer made contact with him. And I don't know if he was on foot at that point or if he was in his vehicle, but he was somewhere near his vehicle because they got his name and his license plate. And he was saying, like, oh, I left some stuff behind or something like that. And they were like, no one can go in there. And he's like, oh, okay. And they didn't know who they were looking for at the time. So they just wrote the plate and the name down. So this is what this is talking about. So he parks, video of the gray Dodge Challenger attempting to turn onto Campus Drive at 12:30. So he has Ring doorbell footage showing the gray Charger parking near campus after midnight. Video of the gray Charger attempting to turn onto Campus Drive at 12:30. He talks about all this in his text messages, you guys. Report of police officer who contacted the gray Dodge Challenger at Campus Drive at 12:30 a.m., wrote down the license plate and later traced the vehicle through the DMV records to Tyler Robinson. Okay, so he didn't get his name. He just wrote down the license plate. Recovery of a Mauser 98 30-06 rifle wrapped in a black towel in a wooded area immediately across Campus Drive in the same area where the person depicted on UVU surveillance footage was seen entering within minutes of the shooting after dropping off the Losi Center roof. Okay, now, this is fascinating because one of the weird and crazy rumors that Candace Owens put out was that they could not find the rifle. But in the trial, we learned, and we already kind of knew this because we're not crazy people, but that they found the rifle almost immediately. They just didn't report it, which why would they? Because he could come back to try to get it. This is just how cases work. But they saw the footage of him running into those woods. Apparently it was just right there where he kind of put the rifle into some bushes. They have photographs of that. And they have daytime photographs now too, because I think what happened was They found the rifle immediately. Now, Candace Owens made up this big long story about bomb sniffing dogs, which why would there even be bomb sniffing dogs there? And that they couldn't find the rifle because it wasn't really fired and all this ridiculous nonsense. But they found the rifle immediately. And what probably happened, why we had the funky photo released to the New York Post, where it was like obviously cops standing around a box with like a flashlight, and it wasn't even a very good photo, and there was sort of a distortion to it. The way that they took the photo had a little bit of a distortion. So what probably happened was they're like, oh, you know what, we should release the photo of leak. They do this all the time. The photo of the rifle to the media because maybe somebody will recognize it, right? Because they hadn't found who this was. And so the cops just kind of go out there, like the ATF or whatever, and they take like a funky shot in the nighttime to be able to release that. And there was like, remember all that hullabaloo of like Ian Carroll saying that the gun wasn't actually the gun and it was a stock image, that's not a stock image photo. And New York Times says obtained. New York Times obtained the photo used of the rifle used, right? So they obtained a photo of the rifle used. And Ian Carroll's like, oh, that's a stock photo, and they retracted that. None of that ever happened. We were fighting with these people like back when this was happening. Like, what are you talking about? There is no retraction. This is insanity. And the father recognized the gun from that photo. How could it be a stock photo if the father recognized it and started texting Robinson about it? So anyway, so we got more information about that. Okay, so one engraved Remington 30-06 cartridge casing fired, recovered inside the rifle. Now, some people were saying, oh, why wasn't there a casing on the roof? Like, why would there, if he shot the gun, why wouldn't there be a casing on the roof? So I've seen that going around in chats and in spaces and on X and stuff. And it's like, because it is a bolt action rifle, it's manual ejection. It doesn't just eject when you fire like a semi-automatic. So a semi-automatic, when you fire, and I'm probably not, please no one attack me. I'm not the best with all the words that describe these type of things around guns. But when you fire a semi-automatic, if you have a round in the chamber, you don't have to pull it back again, because as you fire, the gases and all that stuff push back, and the slide does the thing just from the pressure and the gases released. It makes it do the thing, and then it puts the next round right in, and it ejects. So all this happens very quickly, and it ejects the round. But with a bolt action rifle, that is manual. So you take a shot, and then you have to do this like thing with the bolt, like you pull the lever this way, and depending on I haven't used a bolt action rifle in a long time, but you pull it out, do something, it releases the shell, and then you turn it, and then you push it in and fold it down. That puts another, because like they normally can carry like 4 or 5, bullets in them. And so it'll put the next round in, but it's manual. So when he took the shot, he just jumped up and ran, like right after. He did not eject the bullet, or not the bullet, the casing. Okay, so then 3 engraved Remington 30-06 cartridges unfired. Okay, so like a cartridge is the bullet and the casing together, right? That's what it's called, as a cartridge. Then when you fire the bullet, you are left with the casing, and then the projectile is what we tend to call a bullet. So 3 engraved Remington 30-06 cartridges unfired, recovered inside the rifle. DNA with strong support for inclusion of Tyler Robinson as the major contributor on the gunstock, grips, butt plate, trigger guard, bolt, fore-end barrel optical accessory, which is the scope, and the underside of the receiver after disassembly. So the underside of the receiver means that he would have been taking apart that gun and putting it back together for there to be prints under the underside of the receiver. DNA with strong support for inclusion of Tyler Robinson as the major contributor on the fired cartridge. DNA with strong support for inclusion of Tyler Robinson as the major contributor on 2 of the unfired cartridges. A Dremel tool capable of making the bullet engravings found in Tyler Robinson's home. Okay, so this is interesting. In the little bit of the Lance Twiggs interview that they did for the 102 hearing, so they had interviewed him. Now, I'm pretty sure that we didn't see like his interrogation interview, and I might be wrong, but this is how I'm remembering all this. We didn't actually see the interrogation interview. We saw the 1102 interview. So he had already answered a bunch of questions. That's probably on video. It definitely is. But for the 1102 rules of evidence, for this probable cause hearing, so that they didn't have to bring him in, they did this little, like they brought him in way later to just kind of re-answer the questions and go over just what they needed for this probable cause hearing, so that they didn't need to bring him in. So it was like an 1102. You even hear them mention it. So that is what we heard. And in that, he talks about how Tyler Robinson asked him for the Dremel tool because he said, "Oh, I'm going hunting. I'm going on a camping trip and we're going hunting and I need to engrave bullets." And he was like, "Oh, okay. The Dremel tool is downstairs in this like downstairs closet thing." So Lance Twiggs came off as pretty credible to me. I know not everybody feels that way, and that's fine. But he seemed pretty credible, except for that one thing. That one thing where it's like, I'm going on a hunting trip, so I need to engrave some bullets. Okay. Like, I feel like if somebody said that to me, I would probably be like more like, what do you mean you have to engrave bullets? Like, that doesn't make any sense to me. But also I have to keep in mind the Turkey Tom video where these people were like living in some kind of crazy, like mentally, like ill, like total insanity induced, like coma or something in this home. Like it was the stuff that came out in that Turkey Tom video was nuts. Like these people were like out of it. So maybe that's why he was just like, oh, okay. Like, I don't know. But that seems odd to me. A separate engraved Remington 30-06 cartridge casing fired, engraved with the words "test shot," found inside Tyler Robinson's home on top of a safe in a spare room next to his bedroom, and identified as having been fired by the Mauser 98 rifle. So yeah, that is bizarre, right? Like, so he probably wanted to know what would happen if he engraved the bullet, if they would still fire properly. And so he did a test shot and saved the casing, which is just wild to think about. DNA found on the test shot cartridge with strong support for inclusion of Tyler Robinson as the major contributor. Oh, and before we move on, here it says identified as having been fired by the Mauser. So they tested that casing and it did identify to this rifle that they found. So the test shot did come back as conclusive to being fired by that Mauser 98 rifle. So, and his DNA was on the test shot casing, a Dremel tool bit found in Tyler Robinson's home, identified as producing the engraving on the fired cartridges found in the Mauser 98 rifle and in Tyler Robinson's home. So they might have tested the tip of that bit to see if there was metal that was conducive to the bullets that they found. Additional boxes of Remington 30-06 ammunition inside Tyler Robinson's home. No 30-06 rifle found within Tyler Robinson's home. So that's important. So he had ammunition for the 30-06, a test fired cartridge for 30-06, but no 30-06 in the home, even though there were other guns. Additional Remington 30-06 cartridge cases found in Tyler Robinson's home in the spare bedroom next to his bedroom. DNA found on the cartridge cases from the spare room, with stronger support for inclusion of Tyler Robinson as the major contributor. Perforated paper targets found in Tyler Robinson's home in the same area as the Dremel tool. So that is like basically they showed these targets, these paper targets that had all these like holes in them where somebody was, practice shooting. Statements made by Lance Twiggs, Tyler's roommate and romantic partner, that Tyler was engraving bullets sometime within a month of the shooting. Statements by Lance Twiggs identifying Tyler Robinson as the person captured on UVU surveillance footage during the morning of 9/10/25. Now, this is interesting because the conspiratard weirdos are going around all over Twitter and they're saying that Lance Twiggs didn't even identify Tyler Robinson as the person in the surveillance footage, and this is what they do. They just clip like a tiny piece and they don't show anyone the whole thing. But he says it's hard to tell exactly if that is him, but he looks like him, and he's looking at several, like a group of 3. So he's looking at the first ones first. He's like, it looks like him. The sunglasses, the shoes, and then I haven't seen him in that specific hat, but he's always wearing a hat. And then the grouping down below those ones, he says, okay, these ones down here look much more like him. These look like him, right? That is him identifying, like, you know what I'm saying? They're just being crazy. Okay, text messages between Lance Twiggs and Tyler Robinson beginning at 11 p.m. on 9/10/25, in which Tyler admits to the shooting and discusses his location and activities, including statements that he left the gun in a bush wrapped in a towel that accurately describes where and how the Mauser 98 was found by law enforcement, despite that information not being publicly available. Now, people are being really weird about this too, because they're saying, oh my gosh, he didn't text him I love you until if he left at 4 or 5 in the morning, because that's what Lance said, and then you don't hear from him until 11 p.m. That's a really long day or whatever. And it's like, there could be text messages before that. We don't know. They're only showing, this is the thing, they're only showing what's relevant to the thing, right? There could have been messages earlier in the day saying, oh, hey, what's up? Oh, nothing. I'm just, blah, 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 or whatever. So text messages between Lance Twiggs and Tyler Robinson beginning at 11 p.m. on 9/10/25, in which Tyler admits to shooting and discusses his location and activities, including statements that he left the gun in a bush wrapped in a towel that accurately describes where and how the Mauser M98 was found by law enforcement, despite that information not being publicly available. Testimony that forensic extractions were performed on both Lance and Tyler's phones. Photograph of a note taken by Lance Twiggs found under Tyler's keyboard in his bedroom, referenced in Tyler's 11 p.m. text to Lance, containing statements admitting to the shooting. Okay, so the note, he texted Lance, and it seems like he accidentally, like, he set up a automatic message and then didn't cancel it, but he texted Lance and said, look under my keyboard, right? Well, Lance did and found that note. Well, he took a picture of that note, okay, with his phone. Then at some point, either he or Tyler burnt the note. And there is a picture of that too, because the police found it in the home burnt in like a trash can. Probably the trash can by the desk. Just so dumb. But Lance said in his interview that he did not burn it, that the last he saw of the note, it was on the desk intact, and then it was found burnt. So he is saying he didn't burn it, but so it was either him or Tyler. So photograph of the note partially burnt in the garbage, not the condition it was in when Lance states he saw it last. Statements by Lance Twiggs that when he saw Tyler on 9/11/25, Tyler cried and said he was sorry he did it. So Lance reported that he was walking around the house sort of doing like chores and trying to keep his mind busy, and then he was like he was sort of started crying, and he said he wished that he didn't do it, which is just, I wish he hadn't have done it either. This is just horrible. Horrible situation. And, Charlie was such a wonderful person, and yeah, I wish you wouldn't have done it either. But that is an admission of guilt. So that will be used as a confession. Well, I don't know if they'll call it a confession, but they'll definitely call it admission of guilt. Okay. Discord chat messages sent shortly before 8 p.m. on 9/11/25, identified by Lance as being sent by Tyler, in which he admits to the shooting and described his intent to imminently surrender. Okay, now there has been a lot of online chatter about this Discord message. So the lying, grifting, conspiratard a-holes like Baron Coleman have been saying that he turned himself in at 6:25, which has never made any sense compared to all of the statements from the police, that the sheriff of that county or whatever, the documents, everything lined up that it was later in the day or in the night than 6:25. But because there is some document that says he was Mirandized at 6:25 with no date, they're all like, that's when he was arrested. That's when he was arrested. He couldn't have sent the Discord message. When everybody who knows anything, including Baron Coleman, who used to be a lawyer, knows that you can be Mirandized more than once. And also, from the way it was described, when he turned himself in, he was put into an interrogation room and then left alone while they did interrogations of his family members apart, like the mom apart, the dad apart, and the family friend. And they were all just kind of waiting. And then they took him from there to another place. And that's when he was like booked in and arraigned and all that stuff. So this idea that the Discord message couldn't have been sent before he was turned in is a bunch of ridiculous lies. And then also another ridiculous lie is that Discord came out and said that this wasn't on there. Well, that's a lie too, a misrepresentation of the facts, because all Discord came out and said was that the murder wasn't planned on their platform. They didn't say that particular message didn't exist. Okay. Then they keep saying, oh, well, why didn't they get the metadata? And they did get the metadata. They're not going to show the metadata and all that stuff in the court. Like I said in the beginning of this video, they are just showing the judge their initial investigation that they put into a probable cause statement and filed with the court days after he was arrested, or like the next day after he turned himself in. So that's why they're showing the photos of Lance's phone, that Lance let them take photos with their phone when they showed up of the text messages just for them right then for their investigation. So that's what they had. That's why they're showing the judge that. But then we see the search warrants that were filed on all the devices that they got information warrants to get information off of that they will have for the trial. It's just so stupid. Okay, and then testimony that Discord produced the same chat thread in response to a subpoena. Tyler's voluntary surrender to Washington County Sheriff's Office at 9 p.m. on 9/11/25, consistent with the chat message. So the Discord message, in case you guys don't know, it said something like, "Hey guys, I'm sorry, it was me that killed Charlie Kirk. And so, I'm about to turn myself in." And then they're like, "Oh my God, no." And he's like, "Yeah, sorry, I let you guys all down." Something like that. Statements from Mike Mitchell, a family friend who helped coordinate Tyler's surrender with WCSO on 9/11/25, describing his involvement. Testimony that Tyler's mother and father were interviewed at the time of Tyler's surrender. Video footage from inside the sheriff's office showing Tyler entering the interview room. And everyone's like, "Oh, why can't you see his face? Oh my God." They'll have the whole, this is do you want the probable cause hearing to take like 3 months like the trial is going to take? They don't need to show the judge and this idea that it's not Tyler Robinson is beyond. It's driving me, because they're all acting like this isn't him. This isn't him. The footage is blurry. There's no good footage of him. Well, his parents identified him from the footage. They're all this is not made up. You know what I mean? This is just insanity that these people keep pushing. Now, okay, so Andrea Burkhart says much of this evidence has other sources of corroboration or refutation that are highly likely to be available at trial. This includes cell phone activity, data app usage like Discord, obtained from the extraction. So that's going to show all the activity, like him logging into Discord, him being on the campus, him being outside of the house that they have footage of, him being on the roof. They can even pin it down to that minute of a detail. Trust me, I've seen it in trials. This includes cell phone activity, data app usage like Discord, obtained from the extraction, GPS location data collected by apps on the seized phone, cell site location data from providers showing cell tower connections of the phones, next generation sequencing DNA testing that can deconvolute many of the mixed DNA samples with greater individualization for identification purposes, and of course testimony from other witnesses that with knowledge such as Tyler's parents, friends, and other individuals in the Discord chat. At least some of this evidence, the cell phone extractions, was provided to the defense team no later than March of this year, and so was available for use in the preliminary hearing if it was exonerating. Based on this showing, the chances of Tyler Robinson being bound over for trial on the intentional murder charge is approximately 99.99999%. Where the defense attorneys may have a better chance of success is in challenging the aggravator that makes the charge eligible for the death penalty. So that is why, let me get back on screen. So that is what I was trying to explain to you guys on why the preliminary hearing seemed to be so much evidence and being so strong and long, and it's clear you shouldn't have to show this much to prove that that was him and that Charlie died and all this, but they do for the aggravators, right? And that's where the defense is going to come in and try to those aggravators, right? Hack them out so that they can try to get death penalty off the table. Okay. So that's why they have to death penalty cases are crazy. The aggravator requires proof that Tyler knowingly created a great risk of death to another individual besides Charlie. Utah law requires that the other individual must be within the zone of danger of the charged act, meaning that it is temporally and spatially proximate to it. That's why they were showing. You heard questions in the hearing were there people behind the tent moving back and forth that could have possibly been hurt by this, right? Video evidence of the shooting may establish the zone of danger requirement. The public did not get to see that. However, the state did not present evidence of what can be seen from the low-C center roof from the vantage point of the shooter. So whether the shooter knew other people could be within the zone of danger may be harder to establish. But I also think that the political targeting might be an aggravating factor, and they did provide evidence on that as well. So I don't know if the targeting of that aggravator is required for the death penalty, and she might know better, and that's why she didn't mention it. But I'm just going to say right here, it also comes to my mind that they did introduce that evidence. And so, okay, what I am going to do now is I'm going to go through Jane Doe, if you're not following her in X, you have to, like, what are you even doing with your life? But I'm going to go through her page because she'll have a lot of the evidence that was shown in court that we can look at and stuff like that. And so we're going to do that. And first place I'm starting is with the text messages. So, because I'm just going to go with what I find in order. Okay, so Lance Twiggs and Tyler Robinson's text messages. Full text exchange as it was read aloud in court. Parts of these were not displayed by the video operator. Tyler, drop what you are doing. Look under your keyboard. Lance, what? Lance, you're joking, right? Tyler, F, I tried to delete that. Tyler, I'm still okay, my love, but I am stuck in Orem for a little while longer, yet shouldn't be long until I can come home, but I've got to grab my rifle still. To be honest, I had hoped to keep this a secret until I died of old age. I am sorry to involve you. Now, when I was watching this happening in the hearing with Andrea Burkhart, or maybe when she was describing things afterwards, she said that when he said that, like, I wished I would have taken this to my grave, like, or my old age or whatever. She said that reminds him of, like, hero symptoms. So there's, like, this weird thing that criminals would do where they'll do an act because they're trying to be, like, heroic. It's like a delusions of grandeur, but, like, with a hero instead of, like, a god complex. And she's a defense attorney, so I'm sure she's seen stuff like that before. Lance, you weren't the one who did it, right? Tyler, I am sorry. Lance, I thought they caught the person. Tyler, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet almost enough to get out, but there's one vehicle lingering. Lance, why? Tyler, why did I do it? Okay. This right here. Why did I do it? So I was listening to Andrew Wilson arguing with these retards in a space saying, that are all, Tyler didn't do it, the government's planning this all, blah, blah, blah. When he said, what do you think he meant by why did I do it in this text message? And then the guy goes, maybe he was talking about eating at Dairy Queen. And then Andrew's like, so you're telling me, like, if we replace Dairy Queen in every part of this thing, like, that would make sense to you? And it was just like, these people, like, I don't know what's wrong with them. I don't know if they're doing this on purpose or what, but it's really bizarre. Really messes with your mind. So Tyler, why did I do it? Lance, yeah. Tyler, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you by midnight. In Lance's testimony, he says that Tyler never really mentioned Charlie Kirk to him. So, but this is so, like, I've had enough of his hatred. Some hate can't be negotiated out. So he must have been fixated on Charlie Kirk for some reason. And I would like to know, like, what was he listening to? Why did he get this fixation on Charlie Kirk if Lance is telling the truth about that? Lance, all right, stay safe. How long have you been planning this? Tyler, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it while they were parked there. If they found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all this. You shouldn't have to worry about this. Okay, so they didn't report finding the rifle, so Tyler doesn't know that they found the rifle yet. And this is all like kind of important. Lance, does anyone else know? Tyler, not to my knowledge. Tyler, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off. Or hoping this guy F's off. Are you okay still? Yes, checking spot again now. Will update soon. The squad car has moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so effing loud. Going to see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be the wrong spot. So this sounds like he's on foot, right? Do you think they found it? Tyler, don't know. They haven't published anything if they have. Lance, why did you leave it behind originally? Also, does it have a serial number? Tyler, I don't know if it had a serial number, but it wouldn't trace to me. I worry about prints. I had to leave it in a bush where I changed outfits. Didn't have the ability or time to bring it with. So this is the thing. He found this little spot, and that's where he was, because he goes to the campus, leaves, comes back, leaves, comes back, right? So he's found this little spot where that he's going to and changing his clothes, and he probably has his backpacks there because he had two of them, etc. Was your change of clothes there, or was that also gone, or did you bring those with you originally? Anyway, could you replace the gun, or would he notice? Only thing I left was the rifle wrapped in a towel. I'll bet the canine sniffed it out. That little snitching bastard. Replacing it is unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. Like, Tyler, remember how I was engraving bullets? The effing messages are mostly a big meme. If IC notices bald OWA on Fox News, I might have a stroke. Now, I don't know for sure if those were reported yet, that they were engraved or not by this time that he's texting these messages. But that's also another thing, right? That he knew that they were engraved and what was on them. All right, I'm going to have to leave it. That really sucks. Lance, do you need it for hunting? Tyler, no, my dad wanted to use it to use a high caliber for the rifle hunt. Judging from today, I'd say Grandpa's gun does just fine. I don't know. I think that it was a 2000 scope. Now, I don't know if he means Grandpa's gun does just fine because it shot and killed Charlie Kirk, or if he means like it does just fine because they haven't found it yet. I don't know. Lance, geez. Tyler, on my way home, 3.5 hours. Lance, drive safe. Tyler, delete this exchange. Okay, and it says here that the final text was sent on 9/11/2025 at 7:42 p.m. So we don't have that here, but that's just a note that she made. Tyler, okay, we do have it here. Maybe this is it. Tyler, I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here. Okay, and then these are the images. So hopefully you guys can see that. People are freaking out because there's a crack up here at the top, and so like, oh, it covers the time. people, but you can see the time on the thread just like a normal text exchange. And of course, they're going to have these also in data, like not just in a screenshot or a picture of a phone. So this is her saying more conslop timeline debunking. Tyler was not yet in custody, nor Mirandized at 6:25 p.m. on September 11th. Tyler text was, "I'm going to turn myself willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things quiet here." Okay, and we just learned that was at 7:42 p.m. So that's what this is.
And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction of Mr. Twig's phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
Okay, and then a lot of people are apologies. Tyler arrived at the sheriff's office, around 9 p.m. on 9/11/25, not at 6:25 p.m. or before. So that was the conspirators making up all this nonsense, which has now been disproved in court, but yet they're still saying it.
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
Okay, so this is Andrea elaborating on what she said that we read earlier, where much of this evidence and has other sources of corroboration. So she's going to elaborate on this. She says, "We know that the investigators have already done quite a bit of this and found additional links between Tyler's devices, the Dodge Challenger, and locations in Orem near UVU because they talked about it in their search warrant applications." So here this is, a search warrant was obtained for Tyler Robinson's cell phone. During a review of the data and information stored on the device, I observed a Google Maps route with a start time of 9/10/2025 at 6:46:13. Accounting for the time conversion from UTC, the route start time was approximately 12:46 hours. The route start time was approximately 23 minutes after the shooting. The start point for the route was listed with GPS coordinations, and starting point coordinates were near Mountain Shadow Shopping Center. According to Google Maps, this shopping center is approximately 7 minutes from Utah Valley University campus. The Google Maps route is from the area near the shopping complex to a Quick Quack car wash located on blah, blah, blah. Agent from the Quick Quack car wash at Tyler's agent Draney with the Utah State Bureau of Investigation obtained records and video footage from the Quick Quack car wash of Tyler Robinson's 2013 Dodge Challenger, license plate blah, 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 arriving at the car wash at approximately 12:57 hours on 9/10/2025. Investigators previously conducted a records check and found Tyler Robinson to be a co-owner of the vehicle outlined above. I also observed a second Google Maps route that had been stored on Tyler Robinson's device. The Google Maps route had a start time of 9/11/2025 at 7:33 a.m. Accounting for the time conversion, the route start time was approximately 01:33 hours. The starting point for the route was listed with GPS coordinates. The starting point coordinates were in the neighborhood to the north of and in close proximity to the area where the aforementioned rifle was located near UVU campus. The Google Maps route is from the area where the UVU campus to 31419 Southwest River investigated, previously conducted a records check and found that Tyler Robinson was residing there. Okay, so they're going to have mountains and mountains and mountains of location data, and not just in one way, like cell phone pings and stuff, and GPS pings and stuff, but also all the apps. So all the apps in your phone store all this like crazy amounts of data, and they get all that. So Andrea now has all the search warrants. I did pull them up, but I don't know if we'll have time to go through all that. But I will leave them linked in the description box. Okay, somebody has taken the comparisons from the different times that he showed up on campus that day, and they've put them side by side with the person with the different clothing that showed up with the rifle in his pants, obviously. So side by side comparison: Tyler Robinson versus suspected shooter on the UVU campus before assassination. T. Robinson matches the alleged shooter in facial features, height, and posture exactly, even the way he carries the breast sack. So this is superimposing the two videos. Okay, so this footage here is a mirrored image. So you're seeing a lot of the conspirators saying, "Oh, he's limping with a different leg now." This is a mirrored image. Like the camera, sometimes they do that, right? Oh, they talk about it right there. Dang it. Let's go back. Okay, yeah, it shows how this is a mirrored image. That is why the limp looks different. Okay, so here is no cross-examination on Agent Brian Davis. Andrea Burkhart lays it out: no cross on some highly incriminating evidence, text messages times Discord messages, leaves us to conclude no cross equals no fraud.
No cross for Mr. David. No cross about the timeline. No cross about the Discord chats. No cross about the messages. None of it. No cross on anything. They're carefully crossing, bringing in for the purpose of crossing the forensic experts over rather detailed and technical nuances relating to their methodologies, but not crossing the police officer on some of this highly incriminating evidence. I know what conclusion I draw from that, because there's no fraud relating to that evidence. No fraud.
Okay, so this wasn't in the trial, but this video here is showing how because there are some people claiming that the Dodge Charger looks different in certain angles, and it's showing how the camera is distorting the car, how this spoiler looks farther out than his, and how it's a distortion of the fisheye lens and the lighting. So I'm not going to go deep into that. I'm just saying that cameras do really weird things. So people are sitting here and picking out like every little oddity of the CTV cameras, but I can tell you right now, like even the camera, like cameras are very weird. Like I have a hard time with my studio camera. Let me go on screen. This is a just cheap webcam that I could afford at the time, and it makes my face look weird. Like it. Also, what's strange is like right now, looking at my face, it looks pretty decent. But then when I process this video, download it, edit it, my face looks even just weirder than it does now. But even now, looking at it, like my face will look wider throughout here than it actually is. Like my face is pretty small and not like, but on this camera, it makes my, like, it's all like right now it looks fine, but in processing, it's like the pixels are moving all around and it looks weird. And it makes my bottom of my jaw look wider like than it actually is. And it makes this part of my eyes like look strange. I really hate it because I don't look like I'm supposed to. My hair, like if I try to bring more light into the camera frame, it will make my hair look red and like weird looking when my hair is like a plum color. Like, I don't know, it's bizarre. Like just trying to get this camera to make me look like myself is hard enough. And so when people, and I learned this by watching the Karen Reed trial, there was so much, they were trying to infer so many weird stuff because they were railroading her about the footage that they had and like the pictures that they had from like police dash cam cameras, and then her camera outside of their home filming her car coming and going. So there were actually lights on her house, and it took me a while to figure this out because I kept looking at it over and over and replaying it. And I figured out there were lights on her house reflecting onto her car as she was leaving. So at a certain point, as she's going by her house, the tail light looks like it's white because the light from the house and the snow, because it was snowing, hits each other right at that one point, which makes her taillight look white. But as she drives forward, it's red again. And if that taillight was busted out, it wouldn't be white anyway, because that's not the way that those bulbs work. They have an infuser inside of them that pushes the light up into the diffuser. So it's not like an actual bulb. This is like a brand new Lexus, right? So they're not, but this is how the state was framing it. So the CCTV cameras can do like all kinds of weird stuff. So conspiracy theory people going through and trying to point out all this weird stuff is just like pointless, because they're going to have cell phone data that places him here driving around and stuff, and they're going to be able to track this exact car. So, and there's several videos of people doing this where they're pointing out like this, what looks like this big wide spoiler here actually disappears as the car is moving because of the distortion and the light. Like when he turns his lights on, it does something different. And it's just because cameras are weird. Okay. So here is a photograph of the note that wasn't supposed to be shown. And then there was a sanction because it was an accident, but they were still sanctioned. Okay, so this is important because there is a rumor, like the conspiracy people are spreading out this thing saying that there's a clip of the state telling the judge that you don't see the shot taken, that they don't have that at all. Like Tyler getting, like it's described in the probable cause hearing or statement, okay, that we've had forever, that there's video footage of him getting into position. They describe the whole thing on the roof. He like goes behind this thing for a second, fiddles with the gun, putting it back together basically, and then he gets in a prone position, blah, blah, blah. So in the court, they were going to show an exhibit, not the zoomed in footage, but another footage. And the judge is just asking, does this show anything graphic so it can be displayed to the public and in the courtroom and on the screen? And they're saying, no, that's not in this. So they've taken that clip and they leave out the rest of it where he says, but we do have the footage of him taking, blah, 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 describing it, that they say he says he doesn't have. So this is somebody saying, reminder, this is Kanoa the Great actually, saying, reminder, prosecutors literally said back in April that they have video of Tyler Robinson taking the shot. And that's another thing, like when they did show the zoomed in and enhanced footage of this whole thing, people are saying, the ones who saw it that are coming out and explaining what they saw, they're all saying that they're lying. So here's this, let's listen to this. So this was back in April, I guess.
UVU has a great surveillance system, and they captured the defendant coming on to campus at about 7 a.m., or I think about 8 a.m. Okay, it's clearly him. He's driving his gray Dodge Charger. And I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They captured his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon t-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs to the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence.
Okay, now, the reason why they are not showing the zoomed in image to the public and all that, and that they don't, so this is the thing. People like Ian Carroll are taking the footage of the rooftop footage that we have that they showed in court, that's really far away, and they're zooming it in and going, how could they be saying they have clear enhanced footage when they're just looking at tiny little pixels? There's no way they could see anything. You can't make anything out of this little lump, right? Well, he does not have the original footage. In fact, he has he's recorded footage from a camera taking footage of what was displayed in court of the original raw data. Okay, this is insanity. Like, everybody knows that that's not how it works. If you have of course it's going to look crazy like that, but if you have the original footage, you have way more information and pixels in that footage, and they have ways to make it zoomed in and enhanced and better with that original footage. And so he's using that, which is like literally insanity, to say that the people who saw at the end of the day 5, this wasn't shown to the public, the zoomed in enhanced footage, that they are lying when they say that you can see them take the shot. Now, we will probably play a reporter who was in there, her description of it, but they can see him and is enhanced and zoomed in on the original footage. They can see him, and they describe it in the probable cause hearing. They describe it here, get into spot and take the shot. And you can see, like, it's not a movie, so it doesn't then pan to Charlie, right? But it shows him getting in spot, and it's about 30 seconds. And people are like, oh, how is that so fast? Well, I don't know if they've never shot guns before, but 30 seconds is quite a long time. So, like, let's do it here. 1, 2, 3, 4, 5, 6, 7, probably wrong hand, but I can't do it with my other hand. 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. 30 seconds is a long time to actually sit there and you get it onto the shot. I mean, they act like this is crazy, but 30 seconds is a long time. If you have like a scope and everything, I mean, so yeah, but they are just making a mountain out of a molehill, trying to say that like all these people are like lying about what they saw, and it really shook people up. Like the reports from in there is that Erica was bawling, like it was a very emotional seeing that footage way up close like that. Yeah. And even he says here that they have footage of him taking the shot, and yet they're going around saying in court, the state told the judge that they don't have footage of him taking the shot. Well, and so if they have footage of him getting into a prone position at the edge of the freaking building, what do you guys think happens at 12:23? Like, it's just so bizarre how people act. It's just crazy. Okay, so actually here is her, one of the reporters. So we got to this, so let's listen to her. Heidi Hatch confirms the zoomed-in surveillance video presented in court yesterday was HD and states it very clearly shows the shooting happen.
The Tyler Robinson hearing has adjourned for the day and for the entire hearing at the noon hour today. The defense finished with their final DNA witness from the ATF. After that, the judge allowed the family to view, without it being broadcast, the zoomed-in surveillance video from Utah Valley University. The quality was surprisingly high, a lot more detail you could see of the man that is reportedly Tyler Robinson making his way through campus, up and down the stairs, into the parking garage, and even zoomed in on the roof where you can see the man who is reportedly Robinson lying down into that prone position before the shots were fired. As that came up on that video, that zoomed in video, Erica Kirk breaking down in tears, as well as Catherine, her mother-in-law, Charlie's mother, clinging to each other, hugging each other as that video played out. I can't imagine what that would be like to see those final moments before your loved one died. Extremely emotional end to the court day. This will essentially be court out until September 1st. That's when some final arguments will be made. The judge will decide if this will be bound over for trial, and Tyler Robinson will finally have his chance, if it is, to plead guilty or innocent in this case. We're waiting outside the courtroom right now for the family members and others to leave the courtroom to see if any of them would like to talk after.
Okay, so there you have it. She says that it's zoomed in and you can see the shot being taken. So this woman here, this Brandy woman, she is on like Candace's team. She goes there to the court hearings and stuff and like then puts out lies. Like she put out a lie that Charlie Kirk and Erica Kirk's parents weren't sitting together, even though you just heard the legitimate TV reporter there say that they were, and other reporters have been reporting them sitting together crying. You know, the people that are in the courtroom that are reporters, they will report throughout the day things that are happening, and they have mentioned them sitting together. So she put out that they were not, because the conspiracy theorists have this whole conspiracy idea that Charlie Kirk's parents hate Erica Kirk now for some reason because they think she, killed Charlie. And so she lied about that. And then she lied that there was no high quality zoomed in footage showing anyone taking a shot. The video is shown the same distance as the footage. So she's lying. She's lying. They have clearly stated they have zoomed in footage and that they wanted to show it, and it was not allowed to be shown until the end of the day on Friday when they allowed just the public in the courtroom to see it. So she is a liar. So let's listen to this.
Okay, let me start off. This person is a part of Candace cult. She's an idiot, along with all of these other people that are now saying that the video did not show what we all say it shows. It's because they live under this concept that that person is not Tyler Robinson. The video zoomed in clearly shows the individual getting into the prone position, the timestamps of exactly when Charlie was shot that individual taking the shot, getting up, running off, jumping off the thing. These are the same people that are spreading the lie that the prosecution has no video evidence of the person taking the shot, when they took an out of context clip and where the judge was simply asking, is there any footage of someone taking a shot, because he wanted to be able to alert the family members. People like this person cannot be trusted. They work with Candace Owens. They believe Candace Owens is the head witch of the coven. These people are no different. They're brain dead. They're lying to you because their lies are all falling apart in real time. So they're making their money while they can. The video will come out. None of us are afraid of it coming out. This person will be.
Okay, so here Andrea says, in my opinion, the most damning evidence presented was text messages in which Tyler told Lance that he had left the rifle in a bush wrapped in a towel. This is highly incriminating because it accurately describes the condition the gun was found, and that information was not public at the time. Here, this video shows how the spoiler, and I'm not going to dwell on this, but this shows how when the headlights are off, the spoiler doesn't appear and at the certain angles because it's the light in the camera making that a spoiler look bigger than it actually is. Okay, so this person says some individuals have over-exaggerated the clarity of the video. The video we were shown was visually clearer, slightly zoomed, and showed an expanded shot of the roof, especially on the left side of the video below. The video we saw in court today clearly shows Tyler going up the stairs, hopping the railing, getting onto the roof, finding his position, and going prone before getting up and running exactly when the shot occurs, as corroborated by the time shown on the video. In the video, we saw details such as Tyler's phone in his pocket were much clearer to see and likely be made more relevant in the real trial. Lastly, the video showed Tyler's movement at multiple times during the days and in multiple outfits, and includes his movements into the woods after jumping off the roof. Hope this clears up any confusion, blah, blah, blah. So this is her saying there's no high quality zoomed in footage, whatever, blah, blah, blah. This is showing that it was clearly zoomed in. This is showing how this car matches this car. Here is this Heidi lady saying that this is false under Brandy's, saying that there was no high quality video zoomed in. I don't know why they were talking about it constantly in court and saying that they would show it only to the courtroom if it didn't exist, but this reporter said this is false. Here's Heidi talking about the zoomed in more. She says, one thing I noted with the zoomed in surveillance video is that at every point in the video when the man reportedly to be Tyler Robinson is walking around campus, he's holding a phone, putting a phone in his shorts pocket, and in previous FBI released surveillance, you can distinctly see the outline of the phone in his pocket of his jeans. The state, I'm sure, has cellular data if he had his phone on him where they can trace his movements throughout the entire day. That evidence will likely be getting saved for trial. And I don't know why, so look at this picture. I don't know why people are saying this is not clear enough evidence. So these conspiracy tards are saying oh, this is you can't tell it's him. This is the worst video ever. We have been convicting people of murder using video evidence for the last 50 or 60 years. And let me tell you, it used to be a lot worse back in the day, and yet people were still convicted. It's not like this is all they have. If this was all they had and they were oh, this is all we have, and we say it's this guy, yeah, jury might be oh, that's weird. I don't know. Maybe it is him, and they say it's him, but how can we be for sure? Okay, well, they will not just have this. They will have evidence of his cell phone data and pinning him in all these places, and eyewitness testimony of saying he said he was that he went there and did, well, they'll have tons and tons of other evidence besides just this surveillance footage. It's just mind-blowing the stuff people are saying. Here's people trying to say that the gun isn't the same gun. Now, this image is the daytime image of the rifle, and it's flipped over, and this is the nighttime video with the flashlight, and this does look kind of weird, but it is a strange angle. That's the thing. This is a very low quality video that cops snapped outside of their wherever they were, like ATF agents, I'm imagining. And this image is very low quality, but people are showing it is the same gun. It's just at a weird angle and it's flipped. And it's got bad lighting, like flashlight lighting. So here's the defense objecting to showing the public the zoomed in version of Tyler Robinson, as it's too prejudicial and will play a big role at trial, but yet they say it doesn't exist. So this is the ammo that was used, that they believe, like, the gun people say that these look like soft point Corlocks, Remington Corlocked. I don't know if I'm saying that right, but that's why it expanded and deformed when it hit his flesh and bone, because that's what they're designed to do. And so here's this is how we know, because this is what they look like. And so that's a photo of the other casings found, one of the other casings found in the rifle. Here's the bullet targets. This is the casing that was found in the gun. So here's just more evidence that this was a Corlock. Okay, here is the bullet evidence. So 1, 2, 3, 4, 5. See, maybe this is a zoomed in image of this. So 1, 2, 3, 4 fragments here, and then this lump is this zoomed in, the bullet jacket. And I just saw this and I thought 1, 2, 3, 4, 5, 6, 7. So obviously there's 4 fragments that were taken from his body, and then this is the bullet jackets zoomed in with like 2 sides of it, front and back or underneath, and see how this is flipped. So this is the bullet jacket here at the bottom. This is why they're having a hard time making it conclusive to his rifle, because of the condition that this is in. And then the bullet fragmented, and this is what they were able to pull out of his body. Now, when a bullet fragments in your body, it also leaves like lead storms. So tiny little pieces of it will be spread all throughout the tissue that they can't get. But on a, x-ray or whatever that's called, that you can see all the pieces in there, and it's called a lead snowstorm. Okay, here's the footage of the spot in the woods.
Will you describe what we're looking at in Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel, and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak moved it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
Okay, so that's really interesting. And you can like see it it's not like it was that hard to see. You could kind of like, there's no way that police seeing him go that way and then go that way, the police would not see that. So here we can listen to this of Lance's testimony, because I don't want to play the whole thing, but this is 2 minutes, and this is when he says that he cried a little bit.
11th, what time did you see However on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting?
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay, so there are people that are saying that this is not Lance Twiggs, that this looks like a robot and this is like AI. I know this is like insanity, but remember what I was saying earlier about the webcam. Okay, this is a computer webcam or whatever, in a really bad lit place, and it's probably like it's doing the same for me. Like if I turned all these lights up bright, like I would look like him. I would look washed out, for one, like I was dead. It's crazy. Like, let me get on screen. I have to put like an unbelievable amount of like makeup on just for you to be able to see it. Like, you can barely even tell that I'm wearing eyeshadow on this thing. And you could barely tell that I have like blush on. You can see it, but I have to put like an ungodly amount on just for you to like see it. It's crazy. And I'm not even that great at makeup. So this whole makeup and the camera thing is very odd. I figured out that if I do it while I'm looking at my StreamYard stream, that it works out a lot better than doing it elsewhere and then expecting it to look like how it looks elsewhere here in this spot with this camera on. And so if I turned these lights on bright, my entire face, you wouldn't be able to see any of my makeup, nothing. You can barely make out my top lip. So when I'm talking, this is another thing that bothers me a lot when I'm doing this, is that it looks like I have no upper lip sometimes when I'm talking, but I do. I have very full lips. There are some or a full upper lip with a nice Cupid bow. Like you can see like a photo of me that I used for my thumbnails that you can tell, but when I'm on the screen, you can barely see my upper lip. And like when I'm talking, it goes away. So cameras, like I'm trying to say, do very weird stuff. And so like the way that he looks on this camera is not abnormal to me. It's probably doing the same thing to his lower face as it does to mine, where it like blows it. Like, do you see this? Do you see how it makes it look extremely wide here? Like, my face does not look like that. You know what I'm saying? Like, and sometimes it'll like go away, or like my hair shadow will make it look weird. You know, it's not a very good camera. It's not taking in like enough information, and the lens is weird. So he probably, because there are photos of him and they're putting it next to this and saying, are you saying this is the same person? Yeah. Like they didn't find like a robot to do this. People who watch trials know that this is impossible. They couldn't fake all this stuff. You know what I mean? Like this is just insanity what these people are saying. So this guy is, because they're trying to say that this isn't Tyler Robinson because that he's too tall or something. And they kind of like, what they've done is they've distorted the they've taken still images and distorted them and stretched him out to make him look really tall. So this guy is disproving the nonsense, and this is coming from Candace Owens. She started that, and so this guy's just disproving that. Okay, let's listen to this.
Was that little subtle reference by Agent Hull that the surveillance video together with the cell phone data helped place Tyler in certain locations. The cell phone data, cell phone location data, it has made its first appearance. Guys, it's going to be huge in this case. We already kind of knew this was going to be huge in this case. At least I did, because we can go back on pretty much day one of getting any kind of information. When we got this probable cause statement from, I think this was the FBI agent that wrote this one. No, this was Davis. This was SBI. This was Davis, right? So he has yet to testify, but he will be testifying. The reason why it was really obvious from the very, very beginning that cell phone data was going to be big in this case is this part of the PC right here. UVU surveillance camera at 11:50 captured suspect walking across a grassy area north of Campus Drive, 800 West, turned south through the parking lot, approached the pedestrian tunnel. Before entering the tunnel, suspect paused at the top of the stairs and pulled out what appeared to be a cell phone from his right pocket using his right hand at approximately 11:53, and eventually put what appeared to be the cell phone back in his right pants pocket using his right hand, and then making his way towards the Low-C Center. This is exactly how they are going to piece together the parts of this case, because they've already told us explicitly the video, surveillance video from the morning is very clear. It's obviously Tyler. You're going to be able to see that it's him, but the video from the time of the shooting is not as clear. It's more obscured, more obstructed. He's got the hat on, the glasses, changed the clothes, etc. This is their story. So how are they going to show this is the same person? The location data. The location data. They have his phone. They have his phone. They have surveillance camera that's going to tell us he's in this area doing this thing at this time. And when they find that on his phone, we're done. When they don't find that on his phone, defense is pointing out your suspect did this. Tyler's location, according to his phone, is somewhere else. We're done. It's such important data, evidence in this case, because it will, once we know that it's there, it will either be incriminating or exonerating. This was like the big difference, I think, between this case and the Kohberger case. Also expected in the Kohberger case, if they got location data, it's going to be big, one way or the other. But the problem was they didn't. They didn't have it. And that's why it couldn't definitively establish. Did he go to King Road that night? They don't know. His phone was off. Phone was off. Tyler seems to be using his phone. That's not the only instance either. The text chain with Lance. The text chain with Lance. It is reported in the PC affidavit. What we're anticipating seeing in this this probable cause hearing is the photographs that the investigators took of Lance's phone as he showed them these things. The initial step that they take to preserve this type of evidence before they are able to get the device, extract it, and obtain the original digital record. That's what we're expecting to see is the photographs of it. But they are going to analyze all of that and compare it to Tyler's phone. Maybe the messages aren't on his phone. Maybe he would delete the messages. It doesn't matter. There's going to be a record of the phone activity. There's going to be that record on his phone. there's going to be that record on the provider side. Provider is going to have records of texts received and sent, and the time, and to whom, and from whom. All of this is available to corroborate the state's case. And if it doesn't, it's exonerating. And we'll hear about it from the defense. So the casual, oh yeah, the cell phone data, just dropping that in. That to me was big, just because, yeah, I mean, I knew this because I'm familiar with criminal cases. And in this day and age, the cell phone data is massive. It's massive. It's such.
Okay, and then here's the cell phone warrant. So this is the warrants that were obtained for all of the cell phones. There were 4, 2 I think were inactive. So there was 2 for each Lance and Twigs. And these are the search warrants for all that. And that they downloaded an electronic download of information stored on the identified device for all 4 of these. And then they got a warrant for all the devices seized in the apartment, and there was like a bunch of devices. There were a bunch of devices retrieved from the place, and so we've gone over this before. But MacBook, iPad, HP tablet, computer tower, external hard drive, SD card, USB flash drive, cell phone connected to Raspberry Pi device. They did a full extraction and analysis of all the devices, including recovery of deleted or encrypted data and an examination of account activity stored locally or in iCloud backups. So the metadata, I mean, they've got all this. And so I don't know why people keep saying that they don't have it. And also, it was revealed at one of the last hearings before this preliminary hearing, the state revealed to the judge that the defense has 100% of discovery that they had up until that point. So they have all of this, the defense does. People keep saying that too, like, why didn't the state give the defense the metadata? And it's like, well, they did. What are you talking about? So the DNA of Twigs and Robinson was found on the Talon screwdriver. Here's, I actually have this pulled up on Gray Hughes site, so we can watch that.
Just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information.
Their vehicle belongs to Mr. Robinson.
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up onto campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns.
He made, so Okay, so he made contact with TPUSA. We don't get any more information than that, but obviously he was like probably asking them something like, oh, when's this starting? Or like, how do we, where will the people be? He could have asked whatever.
On foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video.
The dry run.
And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure?
Okay, I just thought of something. So he checks his phone before he goes in and inserts into the tunnel and goes in to do this. And Gray just said this was a dry run. I bet he was checking the time so he could see exactly how long it took him to do this dry run to get from where he was to from the tunnel or whatever entrance to up onto the roof or up into the roof area. He was probably tracking the time.
Eventually.
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building.
Okay, so I ended that video there and I will link it in the description so you can see the whole thing. Okay, let's see what Andrea has to say here.
A beautiful messy ball. At what point in Karen Reed and Richard Allen did you decide something was amiss and corrupt?
Okay, so this, I saw this is pretty good. People keep bothering her with the conspiratard stuff, and she keeps getting she's getting more and more upset about it because she doesn't do any of that nonsense. And so she kind of goes off here. But if you are unfamiliar, Karen, I think I mentioned Richard Allen in my last video, but Karen Reed and Richard Allen are the two most recent examples that I know of that were big cases that there was clearly funny business going on and that they were being framed by the police in the state. So you could tell, like I said, it becomes very obvious if you are a lawyer like Andrea is, or if you watch trials all the time, it becomes very obvious that something is going on. In fact, in Karen Reed's case, she was able to obtain high quality lawyers, such as Alan Jackson, who was one of the most famous defense attorneys in the country, because she sent him the photos of John O'Keefe, her boyfriend, who was a Boston police officer's arm, which was clearly mauled by a dog. Like, if you have ever seen a dog come in and out at somebody and bite up their arm, that is what his arm looked like when he was found out in the snow and outside of another cop's house, thrown out of the cop's house in the snow. And he had bruising around his, well, not bruising, but there was head damage and bite marks on his arm. Okay. Dog bite marks. And the owners had a dog, a German Shepherd, of the house. And they tried to say that the markings on his arm that were clearly a dog bite were because Karen Reed backed into him and her taillight exploded on his arm, because they said he just stood here like this with a drink in his hand and his arm out like that, as she backed into him really fast and shattered her taillight. And then that broke, or that made the marks on his arm, but his arm was not broken or bruised in any way. So when she sent that to Alan Jackson, he immediately took the case because clearly something is going on, right? So it's very obvious when something is going on. So let's listen to her.
At what point do you decide to acknowledge corruption? Well, I'll tell you what happened in Karen Reed and Richard Allen that carried a lot of weight with me. The defense told me that's what the defense was. Okay? Okay? Nobody mind read the case and tried to force feed some theory. I mean, it's just like, it continues to blow my mind, the arrogance of some of this stuff. You have any idea how much information asymmetry there is between people on the internet looking at stuff and the defense team? You know how much more information they have than you do? It's overwhelming. It's overwhelming. So the defense is in the best position to know what the defense is, including if there's corruption. And so when the defense tells me there's corruption, I'll take that seriously and I'll evaluate that. Until the defense tells me, I don't know why anybody would think they got some great insight that the defense doesn't have. I also don't know why anybody would think the defense is here re-saying the same objection for like the 50th time. Okay, the objection that was based on the legal argument that everybody knew they were going to lose. It's pro forma. There is controlling Utah law against it. You are literally doing this to preserve your record for federal habeas corpus review. That is like the level of protecting his rights they're going to. And you think they have fraud and corruption and they're just not going to mention that? It's nonsense. Okay, it's nonsense. So to answer your question, when Karen Reed and her defense team told me there's problems here, they said there was video. There's no video. They've been doing all these shenanigans with the discovery, been withholding all this type of stuff. There's been this whole federal investigation, by the way, that's gone on, that we got all of this information about it that undercuts what the prosecuting attorney has been saying. By the way, Karen Reed was framed. Remember that? Remember that? Karen Reed was framed. Yeah.
So the reason why she said that is because Karen Reed's defense, when she got Alan Jackson hired on, the first thing he said to the press was Karen Reed was framed or is being framed, something like that.
Richard Allen, his attorneys, like the day after they got appointed, roughly thereabouts, issued a press release saying he's innocent, and there's like some very serious concerns about this process and things like that. I took that seriously. You know what I haven't heard one single goddamn word from Tyler Robinson's attorneys about? Factual innocence. Not a word. As soon as they do, I'll be the first one to listen. But I'm not going to force the defense on them. And there's a reason why they don't want to be associated with any of that.
Okay, so people also on the internet keep saying, why won't the judge let anyone see what's going on? Which we did see a lot. We did get to see a lot, so that's a lie in and of itself. But they keep going, blah, blah, blah. Well, it's not the judge. The defense is objecting to like every single thing being shown. So let's listen to that.
I think the big question that a lot of people have, and Blake and I were debating it, and we were talking to some other people trying to figure out why. I think I texted you about it, and I think you had a great answer, so I want you to share it here. Why is the defense basically trying to object to every single exhibit, right? What is the tactic here? Is there anything to read into it?
Well, I think it is normal. As always in a death penalty case, you just do expect to see a little bit more vigorous of a defense than you might in cases that don't have quite as much at stake. That said, it's always a bit of a strategy call, and maybe to some extent a style issue as well. How attorneys decide to manage things like objections in a case. What we saw today was just repeated objections. There's already a standing objection on the record that was filed in writing, but the defense is taking the opportunity to reiterate that objection, explain it multiple times. And so it can perhaps come across as a bit repetitive to be hearing the same.
Yeah, but can't that eventually sort of backfire if you start frustrating the judge, if you start sort of, I don't know, just coming off like obstructionist?
It can. I mean, that is the trade-off. It is a style choice to be aggressive like that can be off-putting. The risk is that if you simply flood the judge's attention with everything possible that you could raise as an objection, then you run the risk that when there's something really good and really, really strong, it's going to be lost in the fog of everything that you've already thrown at him. And he's not going to realize, oh, this time, they really mean it, and there's really something substantive here. So it is a little bit of a risky play, but just given their position and the fact that they do have an obligation to make the best record they can, looking down the road and anticipating future appeals and future post-conviction processes to make sure that they're not waiving any possible objection that he could make at any point of this process, that's going to be a big driving factor for why they are behaving the way they are.
Really fascinating. And I do think it's interesting, especially if they try that strategy in a trial, which I know you've warned us could be as late as 2028, which I'm still like smarting from, to be perfectly honest. But if they try that in a jury trial, I can imagine that would be very frustrating for a jury. That would be very frustrating for the entire legal process, probably Judge Graff. So I think that's important to kind of keep in mind. So
and she goes on to tell him that spring 2028 is optimistic, and I believe that as well. I think it will be at least 3 years before it goes to trial, if it does. And if it doesn't, it will still be 3 years, because that's typically what happens. They stretch, delay, be a pain in the butt, and then eventually the state gives in and will allow a plea. So, because they dwindle down the evidence, I think I'm going to leave. This is to the first day in the timeline, and what I'm going to do is I'm not going to put every tweet or every X post like I normally do. I'm just going to put Jane Doe's account, and you guys can go through it the same way I did, because that would take forever and would be really difficult to do. But I think I'm going to leave the exploring of X there. But before I do, and while I'm thinking about it, or before we move on and while I'm thinking about it, I do want to say that there is like this prevailing thing going around on X of people on Tyler Robinson's side yelling and screaming at everyone because they have made up their minds that they believe Tyler Robinson is guilty, and like, how dare you, that is not allowed. Like, you say you're an American and you believe in the Constitution, but you're saying he's guilty. Well, yeah, because we've seen a lot of evidence and we're able to make up our minds, and that's normal in every case. And so when you are on a jury, they will go through a process to find people who say they have not made up their mind yet, and they're willing to be open and look at the evidence, and that is presented in court. Now, we have seen a lot of evidence that may not be in court. The jury can only consider the stuff that they see in court. And quite often, the public that's not the jury has over the hearing and then the 3 years through the motion hearings, you're going to find out more evidence as they battle out what can and can't come into court. None of that stuff, like say we see something and we're like, oh, that's really interesting, but then the defense wins and gets it taken out to where it can't be appeared in court, the jury will not see that evidence and they cannot consider it. But we as the public, we can see the evidence and we can consider it and make up an opinion. And he is still, and so we can say, I think he's guilty from the evidence that I've seen. And then he is still, by law, innocent until proven guilty. And I expect the state to put on a fair trial and to prove that he is guilty beyond a reasonable doubt to the triers of fact, who is the jury. Like, I expect that to happen. And if they do not do that, then that is not, if they do not prove beyond a reasonable doubt any trial, then I would expect the guilty to, or the jury to not deliver a guilty verdict. Okay, so people can make up their minds, outside. Like if I have my mind made up and they wanted me to be a juror, I'd be like, oh, I've already learned. I have been watching the trial very closely, so I would not qualify to sit on a jury. Do you know what I'm saying? There's all the time like a person whose child gets parents whose child gets R-word murder, horrible crime, right? And then they see the evidence as it's coming out before it goes to trial that clearly this person did it. They're going to believe that he did it without being like a traitor to America's Constitution, okay? So knock it off with the nonsense. And also, by the way, new to like how the court justice system works and how trials work, this happens in every trial and you have people on both sides. In every case, and these are cases that aren't even high profile, just cases that, certain YouTubers are following, blah, blah, blah. There will be people on both sides, like vigorously being like, F you think he's guilty, you POS. And they're like, fighting in the comment sections on all this stuff. So this is normal. There's nothing odd or bizarre about it. So calm down. Okay. With that. All right, I am going to go to YouTube and do a little meandering there before we end this video. Okay, so I picked out this Viva Fry video. I don't normally like to play, like if you've noticed on my shows that I do, I will pick very older videos of creators so that they have had ample time to get all their views, because it's not really evergreen content. Evergreen means always searchable. It's normally like they're making content in the moment. And so when I'm trying to make points and just, add more to our understanding, I like to pick out older videos, but that's kind of impossible in this case. But we're not going to watch the whole thing. And I started this not at the beginning, but I will have this link in the description, and please go give him a view and a like if you can, because this video is actually from today when I'm recording this. Of course, hopefully I will be able to process this and get it out quickly, hopefully. But let's see what he has to say.
There was that skit from Jeff Lewis where it's called the Jeff Lewis Meal Deal. I played it once. Everybody should go watch it. Having a conversation on the internet is like the Jeff Lewis Meal Deal, where you get into a conversation with somebody, you explain it, and then somebody else comes along and says, hey, what were you talking about? And you got to start from scratch. Then you get, I say, idiots, trolls. You get deliberate bad faith actors who come in there and try to convolute the waters, and you try to do good only to understand and spread accurate information, and you are swimming against an endless stream of shit. And it is frustrating, tiring, and above all else, you wonder if you're actually doing any good. People are watching this hearing. It's a preliminary hearing, and people are calling it a trial. And then people are thinking, why doesn't the defendant get to make a defense in this trial? Why doesn't he get to cross-examine witnesses? And then you point this out to people, and they say, well, not to pick on Candace in particular, but let's pick on Candace in particular. She says, the show trial starting this week, it's a foregone conclusion. Tyler Robinson is innocent. We all have to not just fight for the truth, but fight for his defense. And I say, it's not a trial, it's a hearing. Then she replies, well, would you rather me call it a show hearing? It's like, A, that would be at least legally more accurate. Your audience might not think this is a trial. You're going to tell me what you think of this judge turning a preliminary hearing because of its Utah rules of procedure. They don't have grand juries, so they go to preliminary hearings in front of a judge who decides whether or not there's probable cause to charge and to go to a trial. This judge has turned it into a longer trial than Carmelo Anthony's actual trial. And so there are people looking at this saying, this looks like a trial. It smells like a trial, but it doesn't look like he's getting all the rights that a defendant gets. It doesn't look like they're making the evidence beyond a reasonable doubt. And this is a sham trial, not understanding it. Bottom line, probable cause hearing, preliminary hearing for probable cause. The prima facie evidence that has been adduced, it has not been damning for guilt, although to many it is. It's clearly met the threshold for probable cause to go to trial. The people have some righteous and understandable questions, skepticism.
Okay, so what he's saying there is like with the evidence we've been seeing, because it has not been fully like a fair trial, there's going to be a lot of stuff that happens that makes it fair for Tyler Robinson. That's not what's going on. So at this point, if you cannot, like in legal definition, say he is guilty, like throw him away and lock the key in the court judicial system, like he has to be given a fair trial where he can cross-examine properly all the stuff that's brought against him and everything like that. So that is appropriate for that to happen.
There are some weaknesses, for lack of a better word. I don't know where you want to start with this. What do you think of it? What do you think the judge, how you think the judge has dealt with this? Has he made this into a bigger problem than it ever needed to be? And now he's reserved, not judgment, but they're going to plead or file written submissions, and he's going to come back and issue a ruling, I think, in September. What has been your take on all of this? And tell me the.
Okay, so what they're talking about here is that the hearing ended on Friday. Neither side gave their closing, like final arguments to the judge. So they're coming back on, the judge is going to review the entire case that has been put forward for him for probable cause. He's going to review all that. They are going to have their own closing, sort of like closing arguments in a way, to the judge on September 10th. And then he is going to rule on whether or not he binds this over for trial. And then they scheduled the arraignment hearing for like August something, like August 18th or something.
I'm right.
So let's start out with the sort of the process, because there was a lot of, as you point out, a lot of confusion.
And like I said, I think the reason why it was so detailed was because the investigation in the beginning, all this stuff was put in the probable cause statements given to the judge. So they needed to prove all the stuff in the probable cause statement, and they needed to prove everything for every single one of those charges and aggravating factors that we went over before. So this does make it a little more complicated than a regular murder case where it's just like, here's oftentimes in the very beginning, they don't have as much evidence when they arrested the person. Like they just had the probable cause to arrest the person, and then they continued their investigation. And then, so they would probably not introduce all that afterwards. They would introduce what they had to start off with, right? But in this case, they had quite a bit, and there's all these extra factors on to the charges that would result in a death penalty. So that's why it just seems like they're having to provide a lot more than you normally would. Look, I'm going to be real honest with you guys. If I can't get people to subscribe or like, YouTube will literally send aliens to my house. Do you want me to be probed? I need you to like and to subscribe. Thank you.
Out there about what this was and how it fits into the process. So, and let's look at it in the global context, compare it to the federal system, compare it to other states. So ultimately a judge sentence a defendant if they are found guilty by a jury after a jury trial in the United States. That isn't universal around the world. In the United States, the beginning of the process, you can arrest someone and detain them pending a preliminary hearing or an indictment, just based on a probable cause affidavit by a law enforcement officer that is reviewed and approved by a judge. Stage 1 in Utah. Stage 2 in Utah is the defendant can request a full preliminary hearing, which is open to the public and which victims have a right to partake and participate in examining whether there is sufficient evidence to meet the probable cause standard. In many jurisdictions around the world, there is no preliminary hearing ever required, that the government can just accuse you, arrest you, detain you, and then try you without a jury. In some cases, you have secret trials around the world. So the United States affords far more due process of law, far more rights and remedies to a criminal, to someone who's been accused of a crime than almost any other country in the world does. And Utah affords even more due process than do many states in the United States, and then do the entire federal process. I saw constant, continuous confusion that this was a federal prosecution, this was an FBI case, that anybody who supported any aspect of the case was perpetrating Fed slop, not recognizing this is not the Tyler Robinson case of the accused of murdering Charlie Kirk, the aggravated homicide of Charlie.
Yeah, this has been like one of the ultimate just frustrating things is people keep saying like, you're a Fed slopper, and it's like, I haven't heard like one thing from the feds. Like, I've been following this case through everything that Utah has been saying about it and the documents they've been filing with the court. And so it's just ultra frustrating. And, you know, these people, I don't think have been in it as long as everyone else. Like, so it's like, yeah, we're used to this by now. And so Viva Frei, as this was happening, this hearing, he was like so confused all over Twitter. Like, why is everyone being so crazy? Like,
Kirk is accused under Utah state law in a case being governed by a Utah state court judge elected within the or appointed within the county process, being prosecuted by local police, local prosecutors, and local judges, not being prosecuted by the federal government, not in federal court, not with a federal jury trial or anything like that. The FBI's involvement in the case is limited to support and supplemental work. They are not in control of the Tyler Robinson aggravated homicide case. So at least get that part right, which an extraordinary number of people kept getting wrong. Second part is that it's a preliminary hearing, not a trial. Even the quartering kept referencing this as a trial. This is not a trial. This is a preliminary hearing whose sole objective is to determine whether the state has produced probable cause using the lowest standard burden of proof in the entire American legal system. Probable cause is not beyond a reasonable doubt, is not by clear and convincing evidence, is not even more likely than not. It's just a reasonable probability that this person committed this particular crime.
So it's not 50% plus one. It's an even lower threshold than that.
Correct. It's often considered something like 20% if you were to put it in statistical form.
Is it reasonably possible to the point where we then go reasonable possibility? Okay.
Is there reason to believe? Is there cause to believe this person committed the particular crime that they're alleged to commit?
Let me just bring one up here, because Barnes is not dunking on the quartering, and to the extent people call it a trial, fine, that's a misnomer, but at least make sure to clarify what the burden of proof is. It's a mini trial. It's a preliminary hearing, but if you call it a trial, just make sure you qualify the burden of proof.
Yeah. And it's just confusing the heck out of people. So that's the first is that, and the purpose of it is simply to whether or not this person has to.
I will say that a lot of these people are not confused. They're just purposely doing this. We have been dealing with these people since this happened, and they are purposely choosing to be obtuse and crazy about everything surrounding this and acting like there is so much weirdness when there is not a scintilla of weirdness around any of this stuff. Like in this entire case, there is nothing weird or out of the ordinary. They just make things up and make it seem weird when in fact there is nothing weird about it at all. And they are doing it on purpose. Okay. Like at this point, they are literally doing it on purpose.
Stand before a jury to be tried on the case. That's what it's. Do you even get to a jury trial? Do you even? And I consider probable cause hearings not even evidentiary hearings. Why do I say that? Because the rules of evidence don't apply. So to compare this, if you're in the federal system, you get, and one last point, Tyler Robinson got more due process and more rights and remedies and more discovery and more opportunity to cross-examine witnesses and more opportunity to present argument and more opportunity to exclude the public broadcasting of incriminatory evidence than 99.99% of criminal defendants in the whole world and in the United States. So if anybody's out there telling you Tyler Robinson got less due process than other criminal, is lying to you or is too dumb to know what the truth is. So but within that, the probable cause standard, not only is it the lowest evidentiary standard in all of American law, it also has the lowest standards of evidence. It's not even a full evidentiary hearing. It allows hearsay to be introduced into evidence. It allows opinions untested by cross-examination to be let into evidence. It lets in evidence that has not even been subject to the right of confrontation or cross-examination into evidence. All of that is let. In fact, to give you an idea of how it typically works in the federal grand jury context, the criminal defendant gets no discovery at all before the indictment is issued, no right to even to cross-examine anybody at all before the indictment is issued, no right to present any evidence at all before the indictment is issued, no right to discover any of the evidence at all before the indictment is issued. And typically it's one summary witness who just testifies about everything under the world and brings it all in, no matter how much hearsay it is, lay opinion it is, expert opinion, it's been untested and unqualified to be expertise. That's what's normal. And yet you had people out there acting like that was totally abnormal, and somehow they were fixing and rigging the case against Tyler Robinson. Anybody saying that is either overtly lying to you or too stupid to tell you the truth or know the truth. So the Robinson got all of that. He got months. And by the way, people are like, how in the world was this delayed so long? Because the defense requested it be delayed. Like, why isn't certain evidence being broadcast? Because the defense requested it not be broadcast. And they were misleading about this repeatedly. And just lie. I was getting bombarded with, oh, Barnes, what about this? Oh, Barnes, what about this? And it was just another lie, another lie, another lie, another lie.
This is why I you need to understand this. I've been having not a fight, but a back and forth with someone. I think it's in good faith. I don't know who the person is. It's on X, where I said, like, Candace is not dumb. Ian is not dumb.
It is not good faith. I'm telling you right now, it is not good faith. Okay?
They're quite deceitful in the way they present information. And look, good for them, because it attracts an audience of people who want this real life true crime series and be promised things are coming and they never come, and you forget all the garbage they've ever said. They're not dumb. The people who rely on them for accurate information are either just psychotic, like everything's a Zionist to them. I was going to make a joke, like, it's not anti-Semitism, it's anti-Zionism, except every Jew and any Jew adjacent is a Zionist. So they're
welcome to the party, Viva. Welcome to what we have all been dealing with for 10 months, okay? Like, the second you came out and like said anything about, like, okay, this looks like it's Tyler Robinson, like, look at this, that they have the probable, you fed slop, Zionist shill.
When the responses are all, who's paying you? Is Israel paying you? You're a Zionist. You're dealing with retards. And then the other people who rely on, who don't know, are simply ignorant. And I'm having a fight with someone. It's like, well, she sometimes has good information. I was like, a broken compass will sometimes give you the right direction, but if you rely on it, you're going to get lost. And nobody goes camping with a compass that they know is going to be defective 1 out of 10 times. And at some point, they have to come clean and say, yes, we've said a number of things that were just unsubstantiated, unsubstantiatable. And although I'm thinking, like, Candace did good work, I guess, in exposing or bringing.
They will not come clean ever, Viva. Never.
Into light those tweets, the text messages in which Charlie Kirk was complaining about the pressure that donors were putting on him. I guess that's good work. Arguable as to whether or not whoever gave her those text messages gave them to her so she could leak them. And so, but other than that, the amount of disinformation, misinformation that they have spewed that has misled a bunch of people into thinking that he's being railroaded into execution tomorrow is over the top. And if people rely on either of them thinking that they're going to be able to parse through the bullshit from the truth kernels, you're asking to get misled into the wilderness and starve to death. Okay, parentheses closed. Please go on, Robert.
So for trial, you have a right of due process that entitles you to all of the discovery that is either exculpatory, is going to be used against you at trial, or is exculpatory in your favor. You're not entitled to that prior to a preliminary hearing. However, the prosecution already gave that to them, according to the defense lawyers themselves, who are some of the best defense counsel in the country in these kind of cases. You don't have a right of cross-examination. But despite that, they subjected a bunch of their witnesses to cross-examination. They didn't go the sole summary witness routine. Instead, they presented witness after witness after witness, including experts, giving the defense an extraordinary opportunity to have a sneak peek and direct cross-examination of these witnesses long before jury trial. Defense lawyers would beg for all the due process and remedies that Tyler Robinson has received. They also presented the underlying reports, the underlying video evidence not only in its raw form, but also in amplified form. So they got to basically see 80% of the government's case. And this is, again, they have no right of cross-examination, no right to exclude hearsay, no right to exclude expert testimony at this preliminary hearing stage. They do have that right at the trial stage. And that's why I said that people were asking me, what's your conclusion about Tyler Robinson's guilt? I was like, well, the defense hasn't really presented their full defense. All they've done is use it as a sneak peek opportunity to see what the prosecution's case is.
No, and also, what percentage of the evidence has the prosecution presented? At this point, have they had full disclosure to the defense?
Okay, so in the very last hearing that was had before this preliminary hearing, the prosecution told the state or the judge that they have given over 100% of discovery to the defense at that point. Everything they had been given over to them, which would be like basically everything. But if anything new shows up or any new testing or whatever that they do from that point forward, obviously they don't have yet. But at that moment, they had everything, which would include everything used at this preliminary hearing. So, and there was like, somebody clipped that and they spread it around Twitter. So I've heard it multiple times now that they gave 100% to the defense as of that day.
I'm guessing so. Well, apparently they have full disclosure of all the reports, investigative reports, based on some of the defense motions that have been filed. It's clear the defense has everything. They've got all the interviews, they've got all the videos, they've got all the raw evidence, they've got all the expert evidence, and they presented what their DNA expert was. They actually had him testify. What their gun expert was going to say. They actually had him testify. What some of the witnesses that gathered the evidence had them subject to cross-examination. So this is all very unusual, and it gives unusual in how beneficial it is to Tyler Robinson's defense, contrary to all this. Oh my goodness, they're trying to rig the trial. But for the people that are saying this is conclusive as to Tyler Robinson's guilt, the defense hasn't even got started yet. You're not going to present much at a preliminary hearing stage. You're only going to present the bare minimum. I think they concluded they were highly unlikely. We'll get to why. That it was highly unlikely they would get this judge to deny probable cause. So that means no incentive to other than play a little bit to the court of public opinion. No real incentive to put now in front of the judge and in front of the prosecution what some of your defense theories might be. So we don't fully know. Like Carmelo Anthony, I said, wait till the defense presented their defense to see if he has a defense that we don't know about. Ultimately, he didn't. And I suspect that'll be the case here. And I'll get into what I think ultimately happened. But for people to understand, because this process has a limited purpose, it has limited rules, and you don't, as a defendant, get the same rights you do for a jury trial. You don't get to confront any accusers. You don't get to cross-examine anyone you want. You don't get the same power of subpoena compulsory process to subpoena anybody you want. And then you're under no obligation, nor is it often advantageous to you for you to present your own client as a witness, your own expert as a witness, your own. You don't even necessarily want to impeach the prosecution's witnesses that do testify just yet. you might want to save that for the actual trial if you plan on a jury trial. So to understand the purpose of this, understands its limited rights and remedies, though again, within that context, Tyler Robinson was afforded far more than anyone else typically and traditionally is anywhere in the world, but also in the United States. But because it's a limited process, it means you haven't seen the whole defense argument yet. So that explains is there a constitutional right to confront? Yes, it doesn't apply to preliminary hearing. Is there a constitutional right against hearsay evidence? Yes, it doesn't apply in a preliminary hearing. Is there a constitutional right to discovery of the evidence to be used against you and exculpatory evidence? Yes, doesn't apply in the preliminary hearing, though apparently he got all of it already. So now let's go to what happened at the proceeding. So it was a week long, and the evidence against Tyler Robinson didn't meet the probable cause standard. It overwhelmed the probable cause standard.
This is what people don't seem to understand. Overwhelmed the probable cause, not a declaration of guilt. And then people go ape shit, Robert, over there's a disagreement as to when he sent that Discord message, because apparently he was already Mirandized by that point in time, and he couldn't have sent it if he were Mirandized. Although we don't know if he had his cell phone on him for another 3 hours, even if he was Mirandized or in custody at 6:25 and he sent that Discord message an hour later.
And to that point, that was a little piece of defense argument that was made in a motion that didn't make that argument, that said that it was time stamped actually at 3 hours and 33, something like that, which could be like 3 a.m. It could be a wide range of time depending on when the tape started. It had a listing of 6:25 p.m., but the defense never argued it occurred at 6:25 p.m., nor which 6:25 it hurt. And if you understand anything about government technology, you know that it's time, that the time listed can be all kinds of things based on when it was produced, which software app is being used, what the point and purpose of it is.
Okay, so this here that they are talking about is what I showed you earlier that proved like it was a big conspiracy pushed by Baron Coleman and Candace and all them, that he couldn't have sent the Discord message because he was arrested and Mirandized at 6:25 p.m. on the 11th, which is not true. He did not turn himself in until, around 9:00 p.m. on the 11th. So therefore he was able to send that Discord message out. So, and these guys might not know all those details, but I've explained it to you.
I suspected that never made any sense. Why? Because the defense never made any argument that was the case. He checked in after 6:25 p.m. So the whole claim that he sent that while he was in custody has been completely debunked by what was presented at the prosecution, because they have him checking in, and the government and the defense did not dispute this at all.
Well, no, but now to go back to the other argument, Robert, maybe the defense doesn't want to dispute it right now because he's going to get found, probable cause will be found, and they want to save that banger for the trial.
That doesn't help really. I mean, that aspect doesn't help and they conceded the timeline that was present, and they never made that argument. This was someone extrapolating, oh, look, there's something on this that says 6:25 p.m., so we're going to assume it was 6:25 p.m. the day before and not the later in that evening. And we're going to assume that it's when he was in this place, when that never made any sense, because his family never said that, his defense never said that, he never said that, the defense lawyers never said that. So they were just extrapolating something, running with it, when I was like, I'm almost going to guarantee you he was never in custody at 6:25 p.m. on September 11th. The defense has made no such claim, and the government presented undisputed evidence, uncontroverted evidence, that in fact they brought him into custody at 9 p.m., a little bit after thereafter. So that claim has always been wrong, and people have been attached to these things that
I just want to say,
counterproductive. What's going to happen is that people are going to feel incredulous. People are going to look at these people, and they may have legitimate complaints, legitimate concerns, legitimate questions that are going to be muted, and they're going to be ignored because they've gone full Sandy Hook, because they've gone full Candace Owens.
Here, how do you know the phone wasn't confiscated? That'll be for the reasonable doubt at the trial. You're at probable cause.
Ultimately, the phone was confiscated. But here's the phone. People pretending he got Mirandized at 6:25 have one big problem. It's undisputed he was not in custody at 6:25. It's undisputed by the government and the defense and the evidence presented. Undisputed. He was not in. So how is he magically Mirandized at 6:25 if everybody agrees he wasn't in custody at 6:25? You just misread a part of a timestamp that wasn't even the official timestamp. I mean, that was it. You took it and ran with it and not thought about this for 2 seconds.
Well, no, but people are going to say, no, the defense knows that it's not the case, and they're going to save it for trial.
No, that you want to bring in now because you want to exclude the confessions that were off that phone, and they didn't. They didn't.
Okay, so this is something like many attorneys, like including Rakita Law, Andrea Burkhart, blah, 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 have been saying over and over, because people keep saying like, oh, well, maybe they're not bringing it up because they're going to save it for a trial. No, you don't do that. If you have exculpatory evidence that that Discord message could not of him admitting it could not have been sent because they had arrested him earlier than the message had been sent, and so therefore it's impossible, you would not wait years and years and years for a trial. You would bring it up now. You would be writing motions about it. You would be out in the every chance you got in front of a judge, and that's public, which they don't want any of it public. You would be screaming about it, and you would be making hay. Like Richard Allen's defense wrote a whole what was it called? They wrote like a memo. Like it was called something. It was called like, oh, that's gonna drive me crazy. It has a name. Everybody calls it the something, but it had like, because they weren't allowed to provide their defense of what they believed happened with the investigation that they sort of did and the evidence that they had, because like I told you, it was a very strange case. They put together like a whole memo thing and like leaked it out to the public, and yeah, but way before the trial, you know.
So you need to exclude that now, and they didn't. That means they know that's BS. That was ridiculous.
And not just that, like people are saying he's going to be coerced into a guilty plea because they're going to offer to take the death penalty off the table because of the overwhelming nature of the evidence presented at preliminary hearing. If you really wanted to drop the bomb of all bombs, at the preliminary hearings, you would show it's impossible for him to have made the confession. At the preliminary hearings, you would argue his mother never actually turned him in. His mother was in court all week. The defense didn't call her as a witness.
You would claim that's not him on the video. You would claim that's not him in custody.
Oh, you would claim it's not his car.
They make just the argument, the opposite. The defense wants to get the death penalty off the table by arguing, look at how he volunteered and how willing and forthcoming he was in admitting what took place. So.
Okay, so this is actually really astute of Barnes here, because that means he's been watching the hearing closely. So some of the stuff that the defense has brought forward in front of the judge is things like Tyler Robinson's character, like just little things that they've hinted at, shows that they are going to try to use the fact that he has never been arrested, doesn't have a criminal record, never hurt anybody or killed any animals, you know, whatever. I mean, they didn't say all that, but I'm saying, you know, and that he turned himself in willingly without causing a big scene, as mitigating factors to get that death penalty taken off. And that is something that has perked the ears of Andrea Burkhart, a defense attorney, and that is what she has also said. She's like, you can kind of see like where they're going here.
All right. So what was the evidence they presented over 5 days?
You're gonna go to Kananoka the Great, or Kananoka the Great. It's a great account. I'll pull it up. Had all of it. But Robert, go for it, because I mean, people are going to listen to you say they didn't say that. It wasn't him. Nobody identified him. There's no video of the roof, so I'll hear the audience.
I mean, I see
screaming.
these claims made that are completely rebutted. If you want to rebut them, make an argument based on what evidence was presented, not what fantasy land you want to live in. Now imagine people are going to see the power of motivated reasoning. Said motivation is the master of reason. You are never going to make reason the master of motivation. So if you want to improve your reasoning, change your motivation. But you're going to see how powerful it is, because it won't matter how compelling the evidence is. You could have 6 movie director angles showing Tyler Robinson taking the shot, showing the bullet in small and slow, tiny slow-mo going in and killing Charlie Kirk. And people will say, no, because it won't matter. Because their motivation is to not find Tyler Robinson responsible as the trigger man. A lot of these people, not everybody, but a lot of these people. And consequently, those people will make the most absurd, ludicrous, preposterous arguments, because that's the power of motivated reasoning. It excludes any evidence it doesn't want to hear, and it includes nonsense it does want to hear. But what was presented at the hearing was one of the most overwhelming cases I've ever seen in a high profile case. They have him showing up.
Thank you. I have been following cases for years now, probably like 4 or 5 years. I'm not following a case right now. I'm following this case, I guess, but normally I'm following like several cases at a time. And I've kind of taken a break from that, but you never see this much information, especially before the trial. But like even when it goes to trial, they still don't have like video evidence of the murder. They have to really piece this. This is all this is the most evidence that you could ask for as a prosecutor, just like step by step. Then the person tells another person the step by step of what they did, like in text messages, and then they turn themselves in, and then they, talk to their parents about it, and they, and then they brought their phones, so they have entire phone data. There's GPS in the vehicle, so they have the telemetry data of the vehicle. Then he had like a dash camera in his car, which will have evidence. I mean, it's just like overwhelmingly an amount of evidence.
At the scene, they have his car, they have him on video at multiple times, walking normal early on, approaching turning point people to probably, they didn't testify as to what this was, but probably to find out when Charlie Kirk was showing up that day.
Mm-hmm.
Then they have him leaving the campus. They have him at the restaurant he went to. Then they have him coming back to campus. And when he comes back to campus, he's walking differently with what appears to be a gun in his pants, that he's partially hiding part of the gun in his pants while he's carrying a backpack. He walks up, and then one set of steps walks up another step, and people somehow thought he had changed his limp on his leg when all it was a mirrored image of one versus the other. It's the exact same image all the way through.
I had to make sure, clarify, and inspect, because it's not just that the leg limp shifted, also the arm that was swinging freely shifted to the other side. The degree of his backpack to the other side. So it was obviously a mirrored image, but that got spread. Anybody who spread that should never be listened to again. I don't care if they are right 8 times out of 10. They're either reckless, liars, and if they failed to correct their mistake, cowards.
Correct. You have a bunch of people still repeating that lie all over the place. It's like, ask yourself, why didn't the defense ask that question? Because wouldn't that be kind of an obvious way to take apart the case? I mean, come on. Then they have him going up the steps to the roof, running over to the roof, putting the gun together, a sniper's nest present. They have the shot being fired. They have him running off the roof, him jumping off what was only a 2-story roof. It wasn't the Spider-Man roof that like certain people claim. Then carrying what appears to be the gun underneath the towel. They apparently, I think he left the screwdriver on the roof. Then that, by the way, his DNA was tied to another lie that was being put out there by the Baron Colemans of the world, because people keep pointing, oh, Martin, look at Baron Coleman. This dude is a complete fraud.
Well,
I'm sorry. He's not making mistakes. He's a fraud and a liar. Baron Coleman is a fraud and a liar.
Okay, so Baron Coleman and Lionel from Lionel Nation, I forget his last name, are both lying because they are lawyers, so they know exactly what they're saying is wrong. So, other people you could say, well, maybe they just don't know and they're, a little slow or something. But like, Baron is not slow. He is extremely smart, and he is really good with words and using them against his audience and manipulation. And he is a lawyer. So he knows the rules of evidence. He knows what a preliminary hearing is. He knows all this stuff, but yet he is making this out to be like some kind of crazy thing and so is Lionel, who is also a lawyer, because they are lying grifters. Like, they are making the big bucks right now, and they want to keep making it. And like, you make so much more spreading this nonsense. Like, I don't make people aren't sending me like tons of money in super thanks. And, I haven't done a live stream, but like, I see Gary's live stream. He gets some super chats, but they're not like the amount of super chats that Baron gets and Candace gets and Lionel's probably getting right now. These are moments when they're really cashing in. And so that's what they're, doing. And, for whatever reason, people who are really into this stuff, I've seen it too in like the true crime, the really like up true crime people, they will get tons and tons of super chats, tons and tons of super chats. So it's just something about like the drama and like whatever really draws people in, and they really enjoy it and, support it with their money.
Liar. He was out there telling, oh, the DNA evidence, according to the government expert, was 85%, 90% Lance Twiggs. It was literally just the opposite. It was all Tyler Robinson's DNA. He just lied to people about it.
And not for nothing, everyone's entitled to get paid for their good work. And Barron has been raking it in to the tune of hundreds of thousands of dollars in super chats on CommuTube. Set that aside. If the work were good, he put that post out that said 89, 95% DNA on the screwdriver and towel was Lance Twiggs. I'm like, that doesn't make any sense. So I go to the hearing and I just try to go back.
Yeah, I think somebody reported that he's made $400,000 in super chats since Charlie died, and then he's making like $12,000 a week in ad revenue from views, something like that. I could be wrong, but it's quite a bit.
Back to the spot. The mistake was that the expert misspoke, and they came back to not redirect, but they came back to clarify, because it doesn't matter if you misspeak. That's not the scandal. You want the accurate information. She said, no, it was 89% Tyler Robinson, 95% Tyler Robinson on the screwdriver and towel, respectively. The other 5 and 11% was last week. I don't know that he corrected it. And so you call this out. That's not a mistake that cannot be immediately put on blast, corrected, retracted, and apologized. And a number of people still believe it and still say, no, but they said it. Yeah, they said it. It was a misspeak. They corrected it. And I shared the clip of her correcting it for the record. Sorry.
Yeah. And it's what the DNA report itself said. So they have on his weapon that it's his grandfather's weapon that was given to him. They have the inside the bullets were etched with his little phraseology on it that the Lance Twiggs later testified he had requested about a month in advance that he wanted to use the etching to put that on the bullets. We'll get into Lance Twiggs in a bit. So the bullets, the gun is his gun, found near the scene with a towel that was like the towel in the gun seen with him jumping from the roof on it earlier. That one of the bullets had been used, but was inside, it didn't eject. And there are 3 other bullets with his little phraseology on it. That his DNA was found on the screwdriver left on the roof to help put the gun together quickly, and on the gun itself and on the towel that was found at the scene. Then they have his car. Not only do they have him doing all of that on video, then they have on his car being at the scene at the beginning and leaving, and then showing up later right near where he had planted and left, according to their allegations. That's further evidence they have that was his gun, his weapons, and that he had committed it. Then they have him. So they have all of that physical evidence directly tied to him. They have the video evidence directly tied to him. The ownership.
So I heard in a space where Andrew Wilson, because he goes into these spaces because he's sort of taken up the cause of battling these low IQ conspirators out there. And so I saw him in a space with this one guy who was saying he thought Tyler Robinson did it, but that Tyler Robinson used a different weapon and hid the weapon they found in the woods as a way to distract the police from him. And that he had to have used a different weapon. And so, but then why would he text Lance about needing to get that weapon, and why would he have went back to get that weapon and then got his plates ran by a police officer that was, managing the scene overnight? And it's like, doesn't matter to this person. And it's like, okay,
evidence directly tied to him, the DNA evidence directly tied to him. They tied the bullet forensics. And I know there's certain people that just don't want to believe this, but you did a good interview with one of the best bullet people in the country, that indeed the bullet found in his body comes from, it matches a 30-06 bullet. Now, someone was like, Bunch, but they didn't match the bullet exactly to the gun. Yeah, when a bullet fragments, you can't match a bullet to a specific gun, but they did match it to a 30-06 like his. And given the kind of ammunition used that they found that was rested in the gun, it is the kind of bullet, as you can explain, that is consistent with the injuries caused with Charlie Kirk.
Well, I was going to say 2 things. Is the expert? He's just an ammunition repackager, according to many. The car, I want to bring this up because this is another one. And again, people, this is not the trial, proof beyond a reasonable doubt. This is the preliminary hearing. People are saying it's not the same car. Now, I'm not an expert in vehicles. I don't see what people are seeing in terms of the fender or whatever that's the wheel I circled. That I don't see a difference between the two cars. They say that he had an aftermarket air splitter or something on the front of the car. I, for the life of me, don't see it. But when it came to the bullet not matching, that's a lie. And that is a misphraseology that is either accidental or deliberate. It's not that it didn't match. It's that they couldn't conclusively match it. It was not definitively mismatched. It was that they couldn't
because
definitively
it fragmented.
Because
which,
it
by the
fragmented.
way, is very commonplace. Whenever this happens, you can't match the bullet to a particular gun, but you can match it to a particular kind of ammunition that was used. And when they identified the ammunition, it was what some people in the gun world had suspected from the get-go, which was that it was the kind of ammunition that would not, in fact, necessarily cause an exit wound. May commonly cause an exit wound is not the same as necessarily cause an exit wound. And that, in fact, it is consistent with, and there's plenty of evidence of that you can shoot a 30-06 at that distance and not cause an exit wound, depending on the angle, depending on the ammunition. And in fact, it matches up with the kind of ammunition that in fact, is intended to almost like blow up inside you and fragment, and thus not leave an exit wound. Well, a range of people had been explaining this for months in advance, but the evidence was consistent with that presented at the preliminary hearing.
Mike Cernovich has just been pulling up old threads that are not created contemporaneously of people on Reddit forums saying shot a deer, didn't go through. Now, people are saying the bullet is intended to mushroom, not fragment, because you don't want to be picking out, pieces of lead.
Okay, so I am not like an extreme expert on this. I did research a bunch of this stuff, and I went through like war medical journal, investigative, like forensic journal literature, medical literature from World War II and I, because this was the caliber of bullet that we used in all those wars. So there's tons of like evidence about it that the medical professionals have written about, and it's actually very common, and they call the spine a bullet trap actually in the medical literature. But so I am, and I've also been listening to legitimate experts, not trying to like lie and make, hundreds of thousands of dollars off of this whole situation. The way that this projectile works is that what it does is it goes into an animal, and as it hits flesh, it doesn't even have to hit bone, but as it hits flesh and cartilage and arteries and the pressure of the blood and everything, and you're aiming for the heart when you shoot a deer or whatever, and you've got to go through the rib cage, which is not very strong, they say, and then it goes through and it goes into the heart. And what it does is it starts mushrooming, and it peels back from the jacket, and then that causes the bullet to release all of its like a shock wave into the body of the animal, and it could exit, but the point is, as it's mushrooming, it you know what I mean? And really just concussion and like, makes the heart explode and all that stuff, so that you can ethically kill the animal properly, because these older bullets, or like Full Metal Jackets or whatever, they would go through the animal, and then often you would have to track the animal because it didn't take it down right away, and so it runs, and then you have to track the blood trail, and then you'll find the animal as it's eventually bled out enough and is like lying, and it could still be alive, and then you have to like, you know what I mean? So these bullets, as technology went forward, they will actually mushroom and expand inside the animal and cause a shock wave, really dump all of its energy, its kinetic energy inside the animal, and like drop it quickly. And so it's not meant to fragment, but very often when it does hit bone, it does fragment. Okay, so it is meant to mushroom and cause the concussion, but oftentimes if it hits something hard, it or just, in the right circumstances, because sometimes like bullets just do weird things, it will fragment. Okay, but you're not wanting it to fragment. It's just that may happen sometimes, right? I hope I explained that right. But that's what other people have been saying that know these things.
From a deer. And this is what I asked Phoenix Ammunition. He's like, yeah, that's what you want. There's a reason why these Remingtons are cheap. People get them because they don't always behave like mushrooming. Sometimes they fragment, and that's why people pick the more expensive rounds to go hunting, and they use these for range shooting. So whether it's supposed to mushroom, it's not supposed to fragment. It often does, and there are documented cases. You can go back to the internet back in the day of people saying it didn't come out. And all this to say, right now, if you want to raise a reasonable doubt on the bullet, what was used, it's not at the preliminary hearing. Right now, is it probable that this crime was committed? And if your argument is that it's not the same bullet because whatever, that'll be at the stage of the trial, not at the stage of the preliminary hearing.
Correct. Then the other, so they've matched him to being at the scene with video evidence, matched him to the gun, the towel, the screwdriver by DNA evidence and ownership evidence. They've matched the bullet used to being with the kind of bullet used that killed Charlie Kirk. And then they have confession evidence that he told Lance Twiggs repeatedly. He left a letter behind for Lance Twiggs to read, and we'll get into that getting published and why the judge originally didn't want it published, but that he had done it. That Lance Twiggs said he had done it to him verbally the next night, or the night thereafter.
And by the way, we have had this letter. We just didn't have the picture of the actual letter, but we have had stuff that was in the letter because it was released in one of the search warrants that got unsealed before this preliminary hearing a couple weeks ago. So we have actually had that. Either the full contents or at least most of the contents of the letter we already had. So we knew what it said. And all these people like, what do you mean you have a letter? Like, it says that it said to destroy the letter. And it's like, yeah, well, Lance took a picture of it and it says it in the charging documents. That's why we know what the letter says. This stuff has just been driving me crazy for like 10 months. It's literally insane.
The night of, that he also confessed to his Discord pals. And there was at least an implicit reference that he had confessed to his parents by people that were present. By the way, I kept seeing Lionel Media, who was coming up with legal standards that made no sense, evidentiary standards that made no sense, and I get him piggybacking off of the Candace clickbait train. But this was just, he was saying things legally that were misleading people, and as a lawyer, he should frankly know better. But in terms of what the probable cause standard was, what's normal for this process, victim participation rights, public broadcasting rights, all the rest. But, I like Lionel. Lionel's a very informed, intelligent commentator on a lot of subjects. But on this, he was just going places that did not make sense from a legal perspective.
I didn't know who he was. I thought he looked a lot like Mandy Patinkin out of.
He does. He does.
Yeah. So, I saw him. Okay, you're gonna go down here. Oh yeah. Headphones off. I saw him saying some things which were, questionable at best. I don't know him well enough to be rude with him yet, but we'll see if it gets there.
Part of the problem was he was talking about confession standards that are applicable to government confessions, where you're worried about coercion in inducing the confession. None of this confession evidence was Robinson confessing to the government. It was Robinson confessing to family, Robinson confessing to his lover, Robinson confessing to friends. That confession evidence is not bound by the coercion standards applicable to government confessions. Part one. Part two, as people say, well, Barnes, that's hearsay. It's an exception to hearsay. Now, again, for probable cause standards, you can introduce
hearsay's admissible.
But this is also admissible at trial because it's an admission against interest. The rule about hearsay is we don't trust evidence of somebody told somebody something. We only trust it when it has some unique indicia of reliability. So there's a whole bunch of exemptions and exceptions to hearsay. Indeed, it's probably the number one thing you learn in evidence class in law school is not what the hearsay rule covers. It's what the hearsay rule exceptions are. Is it state of mind? Is it, is it a imminent excitement? Is it imminent death? Is there any reason to believe the nature of the statement is true?
Okay, so for example, excited utterance. So in what was that crazy guy's name? I can't think of his name. I'm so tired. There was this big music mogul guy that was like huge, famous. Many people, unless you're older, won't know who he is. But he worked in the music industry and came up with like unique sound. I think like all kinds of crazy stuff. But he was this huge guy. It was like he repped like the Beatles, I think, maybe like just everybody. And he would go on like, he was famous. He was super famous and he was super rich. And sometime in like the 80s, maybe 90s, something like that, he like straight up killed a lady. Like and Alan Jackson was his prosecutor. So Alan Jackson, who's one of the most famous defense attorneys in the country, was a prosecutor to start out with. And he was a really good prosecutor. And he was the prosecuting. So maybe it wasn't the 90s. Maybe it was like the 2000s. Oh, what was that guy's name? Hold on a second. This is going to drive me crazy. Okay. Derail. Okay, so it's Phil Spector. So Phil Spector is the music mogul you're referring to. He is a legendary but highly eccentric and volatile record producer known for the wall of sound technique in the 1960s. He worked with artists like the Ronettes, the Crystals, Ike and Tina Turner, and later the Beatles and Ramones. He had a reputation for bizarre behavior, carrying guns, and a history of threatening women. In February 2003, actress Lana Clarkson was fatally shot in the face, in the mouth, inside Spector's California mansion, often called the Pyrenees Castle. He claimed it was an accidental suicide, but evidence and witness accounts pointed to him pulling the trigger. Alan Jackson led the case against him, the first trial. So the first trial ended in a hung jury, and then the retrial was in 2009. So the first trial was in 2007. Now remember, this event occurred in 2023. This is why I'm telling you, people who don't know anything about trials, who are like, oh my God, what do you mean it's not going to happen in a year? 2023, so it's 24, 25, 26, 27. That's 4 years. Then it ended in a hung jury, and then it went to retrial in 2009. So happened in 2003, didn't get the conviction finally until 2009. He was convicted of second-degree murder and was sentenced to 19 years to life in prison and died in 2021. He had a bunch of famous attorneys as well. Linda Baden, Linda something. She has like two last names. She was his defense attorney, one of his defense attorneys. These are all famous people. But my point of this was that he said an excited utterance, because what happened was, as it came out in the trial, women came and testified that he did this kind of stuff to them as well. And so he would like get them alone or whatever. They would stay over for a dinner party, and then they'd be helping cleaning up, and then all the guests would leave, and then they would try to leave. So the second the women tried to leave, he would suddenly have a gun, and he was like heavy drinker, so he'd be drunk and he'd have a gun, and then he would like gun play with them all night, frightening them, putting it up against them, scaring the crap out of them, making them lie in bed with him while he's got a gun pointed on them, just terrified out of their mind. And so but because he was famous, like nothing ever happened to him. And so then eventually he brought this actress home one night after she was a waitress and somewhere, or she was working at like a club for famous people, and she was part of the going in and out girl that brought like the drinks and stuff. It was like this high class club. And so he took her home from there, and she was just going to stay for like a couple drinks or whatever and then leave. And when she wanted to leave, he did the gun thing. And so she was like near the front door sitting in a chair and had her purse on her shoulder that then dropped when they came in and found her body. It had kind of fallen from her shoulder, but because it was like a strap. And what he was doing was he was playing with the gun in her mouth, and it went off. And I don't think he meant for that to happen, right? So anyway, he said an excited utterance, is what they call it, to his driver who came running up to the door, and that was used in court against him, even though it is hearsay. There is an exception for excited utterance, like in the moment you say something, you know, like I killed her, or like I forget what he said, but it was like holy, you know, like something like that, you know.
Even though it was made by a person outside of court. And one of those predominant examples is an admission against interest. We believe it's true because it's not in your interest to make that statement. So consequently, all of these confessions are likely admissible confessions. And when everybody was saying, and by the way,
that trial was, oh my gosh, let me look up how long was the first trial. Okay, so the trial started in, jury selection began on March 19th, opening statements began on April 25th, and it did not end in mistrial until September 26th. You guys, it's the longest trial in the world. It goes on, and his lawyers just like every little thing they like, and they talk for like 9 to like 15 minutes on like one sentence, right? Of the trial that they're like arguing, they're like, you know what I mean? That they made it take forever is insane.
They got it from his phone. In terms of the phone statements, they got it from his phone. They got it from his lover's phone. They got it from the text mail services. They got it from, in the case of the Discord services. So they have multiple layers and levels of authentication.
And for those who were out there saying, oh, all they did was take a picture of Lance's phone when they examined him, lie. They from what I understand, they extracted all the data using Cellbrite, and it's now some people are going to say, and I would raise this in defense come trial time. All of those confessions are very, very self-serving, to the extent that they're you could raise doubt as to their legitimacy. For the time being, they exist, and if Tyler says they weren't me, Lance Twiggs wrote those confessions because he's the one who did it, and he was trying to get himself off the hook. I would have no problem entertaining that notion, but the confessions, colloquially described, exist, and then the only question is going to be, did he send them? Did he write them? Or was it, the feds writing it for him? Was it someone else? Did anybody else have access to his Discord chat? And is he a patsy? Those confessions are fake, but they were put there to make him as a patsy.
Well,
okay.
And that's where I think his confessions, they're saving for trial, the confessions to the mother, to the father, and to the deputy, that they hinted at, but didn't get into in detail in this preliminary hearing. It also was the case that I know the main evidence. So the evidence, frankly, is overwhelming against Tyler Robinson that he is guilty of the murder, aggravated homicide of Charlie Kirk. That he meets both the standards for first-degree homicide and aggravated homicide to meet the death penalty in Utah. Does that mean he is guilty beyond a reasonable doubt? No, because I have not seen a full, robust defense, which would only be presented at a trial, at a jury trial. Now let's go into two other issues that people like Lionel kept getting wrong.
No, Robert, before we do that, that was not it. Barnes is a paid shell. Prove me wrong from Daisy-JR.
What is a shell? So I'm like a bullet. I'm like a boom.
No, this is the foreign accounts. He's a paid shell.
Right, exactly. So a lot of confusion out there, including by Lionel Media and others. Now, I can understand it from Lionel. I think Lionel was involved in the law back in the 90s. He's commented on it since then, but I don't think he's that active in the criminal world, to my knowledge, criminal defense world, to my knowledge, or the prosecution world. Maybe he is. And maybe he practices in states where this is not an issue. It began even before this, but it really took off in the 1980s and 1990s, early 2000s. Traditionally, the criminal justice process was just between the state and a criminal defendant. They were the only parties to the case. Sometimes the media could intervene for the purposes of asserting their right of press and the right of public access to court proceedings. And sometimes third parties like Mike Cernovich intervene in the Epstein case for the purposes of open access to the court system and as a matter of publication and the right of speech and press. What's changed that is a bunch of states and even the federal government have passed laws creating rights for victims, including victims' representatives. In the case here, Charlie Kirk is the direct victim, but he can have victims' representatives because he is, of course, deceased, and his wife and his parents. If his children were adult children, they could have representation. Sometimes the minor children have lawyers as kind of guardians ad litem representing them in these kind of proceedings. And effectively, victims were given victims' rights, were given rights to participate in the process. So when people like Lionel Media and others were saying there's no other participants other than the defendant and the state, it's just wrong in Utah. Constitutionally and statutorily, victims have a right to participate in a bunch of the proceedings. I saw certain people in the Candace crowd suggesting there was something weird about Erica Kirk being present there. It's like, no, that's her statutory and constitutional right under Utah law. It's like, how did people think the Epstein plea got blown up? The government didn't want to blow up the Epstein plea. The Epstein didn't want to blow up his plea. It's because victims have expressed federal rights that a federal court said their victims' rights were so violated, he could completely invalidate a negotiated agreement between the government and the defense. And yet Lionel Media appears to be clueless about this, even existing, even though he's been covering the case. So there was nothing at all unusual about Erica Kirk's presence or Charlie Kirk's parents' presence. So
they're just saying that because they want reasons to make Erica Kirk look fishy and bad. What case do you ever see where the victims, they are considered victims because their husband was taken from them in a crime? Okay, that makes them a victim, but then they're also representatives of the victim, being his family. So it's two things. And in what case, when you have a murder of someone's child or husband, do they not show up to court stuff and things? Like, I saw people put on there, why would his parents even come to just a preliminary hearing? Why would they not be there? What world do you people live in? Like, what? The family is always there for these type of things.
They have a right to partake and participate in the proceedings, a right to advocate before the court concerning those proceedings, and a right to advocate for the further publication and broadcast of what evidence was introduced in those proceedings. Now, let's go to the public right. You have the press right, and you had members of the press who are represented by counsel there. And you had the broader public who really doesn't have anybody representing him, but the judge is supposed to be enforcing their rights, which is the rights to have any public proceeding open to the public. Your right to petition the government for redress of grievances under the First Amendment to the United States Constitution is guaranteed under the 14th Amendment against the states. But, I just filed a petition for cert to the Supreme Court of the United States for someone whose rights to open access to the courts were violated in the state of Pennsylvania because she was criminally prosecuted and criminally punished based on her tape recording her own proceeding, which documented in detail fraud and corruption in the court systems of Pennsylvania. So that is a federally protected right against the states, and most states have analog provisions that require open access to the courts. So the judge was trying to balance that throughout this preliminary hearing process. He's a very young judge, a very new judge, put under a lot of criticism by both sides. What is he trying to balance? He's trying to balance the victim's rights to participate in the proceedings and the public's and the press's right to publish those proceedings and the public's rights to open access to those proceedings against a risk of having a partial and prejudicial jury that is incapable of being impartial for adjudicating Tyler Robinson's potential guilt at an actual criminal trial later on. And that's what he's trying to balance. My own view is they overweight the defendant's interest in these cases, just like they overrate the government's interest in these cases, when they fear being incapable and unable to pick a impartial jury. The reality is there's going to be at least 20% of people in that jury pool in Utah who don't even know who Charlie Kirk is. Least of all, Tyler Robinson, the murderer, all the rest.
Okay, so I have been saying this ever since the beginning because lots of people who love Charlie Kirk are very concerned and have been from the beginning that Candace is going to taint the jury pool. Like, what if, they get candy tards in there? What if they, all this stuff? And it's like, look, you have never watched a trial from start where you find out the person has been murdered. You find a case, you're following it. They arrest somebody. Though I have followed cases from that point. People do this all the time. This is a thing people do. They pick a murder and then they follow that case and to its conclusion. Sometimes 5 or 6 years later, you're following one specific case for years and years, right? The Karen Reed case that I followed for like over 3 years. So when they come to a jury selection, they, depending on what the heck is going on, you know, if it's like really if it's really high profile, what they will do is they will just bring in like a ton more jurors than normal. So like they'll bring in like 500 jurors for jury selection. So jury selection could take like 2 weeks, and the defense has like a whole team that is for this, that does this type of thing, jury selection. And the state will have a whole team that works on this type of thing, where they read people, they're looking them up, they're looking up their social media, they're doing all this stuff. They have questionnaires. They have to go, each person has to go in front of the judge. They are subjected to questioning by the judge, by the prosecutor, and by the defense. And then they systematically, like the defense is allowed to just completely for no reason get rid of X amount of people, and so is the state. And then the judge, I think, just retains that ability. And it's this whole process that goes in and out, people all day long. Okay, I like them. Let's research, you know, team, you know, and they're like doing stuff. And there's this whole process to narrow down 12 people who will be fit for a jury. And it's a fair and it's a unique process, and it's a robust system. And they always, you know, sometimes you have juries that do weird stuff that I don't agree with. And I think a jury trial is very risky, especially nowadays, because you have so many people who don't know what reasonable doubt is, don't know what, you know, anything, you know, about our country. So, you know, you risk that kind of a stuff, but for the most part, it works really well. And you don't have to have never heard of Charlie Kirk or know that he was killed. You just have to have not made up your mind yet and say that you're willing to, you know, fairly judge the evidence, and only the evidence that comes into court. That is all you are allowed to judge. Okay. And people take this seriously. Like jurors really, really do. Jurors really take this, like when they are selected and they're having to give over their life to this thing, they take it very seriously, if that makes sense. So people do not need to be worried about and then plus this is going to be like 3 years away. And so many people will drop off even following it. Lots of people will not even care by the time there's people who don't even know who Charlie Kirk is, believe it or not. I know it's crazy, but.
So the idea that you cannot pick an impartial jury is simply belied by the evidence case after case. This isn't particular to that county, so you don't have to be concerned that the county has just been flooded with unique levels of prejudice, and so you have to go to a different county or a different state. This is more of a nationwide phenomenon. But while we're immersed with it, your average American, you know, 30-40% of them, I would say 30%, about a third of Americans because remember, a large number of Americans don't ever vote. You know, within that group, over half, but they will be within the jury pool in places like Utah because they don't require voter registration in many of these counties and states and jurisdictions for jury selection in criminal cases, because it raises its own set of constitutional issues if you were to do that. You can find through jury selection in voir dire to make sure nobody's. So I've always thought that's overestimated. We should favor the right of open access to the courts, and there should be compelling and convincing evidence, none of which I saw presented by the prosecution or the defense. They can get the court to order a survey to be done, for example, to survey the nationwide local communities, what you'd be concerned with here, as to how many people even know about the case. My guess is you'll have at least 1 out of 10, 1 out of 5 in that range of jurors who will know very little about the case. But because the judge is concerned with that, and because they often are concerned with that, what he didn't want broadcast and published was the most inflammatory evidence against the defendant. I think he made a mistake there too. The evidence you're concerned with, the people hearing and seeing, is not evidence the jury's going to see anyway. You're concerned with evidence a jury might never see. That's what you're concerned with. Now, I understand his concern with the video evidence. That's why he focused on the most inflammatory close-up evidence of him getting and close-up evidence all the way that would negate all these people and evidence you never see. That's what you're concerned.
Okay, so did you hear what he just said there? You're more concerned with the evidence that the jury will never see, not the evidence that it will see. And that's what I was trying to say earlier, is like a bunch of the stuff that there's evidence for may never come into a trial because the defense, this is a good defense team. They can fight for things and they'll find reasons for it to be not put into the trial in motions in limine and stuff. Like once we get into pretrial motion hearings, all this stuff will be litigated out in this is okay, this is not okay. You can't say it this way. You can't play this clip here. All this stuff, right? So that's also what he's talking about.
Now, I understand his concern with the video evidence. That's why he focused on the most inflammatory close-up evidence of him getting into the sniper position to take the shot and then run away. And then the and close-up evidence all the way that would negate all these people diving down rabbit holes. It's not really his car. He's actually too tall. No, he's actually too short. No, it's actually not him. No, it's actually bags over here. No, that's not a mirrored image. They're going down rabbit. They're going to be embarrassed. They're going to be humiliated by anybody who has any common sense at all. They're going to have to sit there and say, look at me, I'm a complete BS artist, and say it over and over again with complete garbage, provable garbage. It's a mistake. I've been encouraging people to point their questions in other directions that might actually be productive. So, but ultimately he chose not to broadcast the close-up video evidence. He did broadcast it to the victim because the victim's rights, the Erica Kirk and Charlie's parents had a very effective advocate in that regard in the courtroom, balanced out being really strong without being too strong. It's hard to do in that setting. You want to push the judge, but you don't want to push too hard. And the judge ended up saying, okay, you folks in the courtroom can see this up-close video evidence, but it's not going to be broadcast to the world. The reason why he didn't want the confession letter broadcast to the world is his fear was that visual evidence and that visual image of that confession letter would be it's the kind of evidence that would stay in everybody's head, and he wouldn't be able to pick an impartial jury. Again, I think he overestimates how many people are actually following this. If you understand how people operate, normie Americans. I run into normie Americans who don't know who Charlie Kirk is. So, I mean, that's just the Tyler Robinson, like who, what? Because it's part of our world doesn't mean it's part of their world. So I don't concur with his decisions, but I do think he was trying to do a diligent job of balancing these interests. And he didn't want to look like he was out to rig the case in any level against him. That's why he gave him all the discovery he wanted, gave him all the time to delay the hearing he wanted, has even delayed it several more months in order to allow the defense to present entire written briefing on why different elements may not have been met because he's charged with a multiple of other crimes too, in terms of having a gun, obstruction, etc. All of that evidence that he wants to give them he's bending over backwards to make this trial as protective of Tyler Robinson's rights as humanly possible. He's put very strict gag rules on the government and anybody connected to the government in order to try to protect him. And frankly, the bad faith actors like Candace Owens, like Ian Carroll, like Baron Coleman have utilized this to the benefit of raising a whole bunch of absurd and asinine accusations and allegations against Charlie Kirk's closest friends and family. I've said from the get-go that Candace Owens is acting in bad faith. If you're acting in good faith, so let's go to, does the evidence exclude the possibility of co-conspirators, exclude the possibility of accomplices, exclude the possibility of other bad faith actors?
Not only does it not, I think it necessarily implies or implicates other actors. Advanced posts indicating something was going to happen or knowledge of a plot. I still don't. I know it's a belief, and I know there's not much evidence other than what we saw that George Zinn, if he was there by accident and then spontaneously made the decision to distract to allow the real gunman to get away. So someone's going to win the Powerball. That's Powerball levels probability. Lance Twiggs clearly had more information, more knowledge than he's letting on. A lot of this information that he provided is quite clearly self-serving. He didn't know what was going on. He gets the text the night of, and then Tyler comes in the next day and he's like, he still doesn't believe that he did it, even after it's broken all over the news, that he was engraving the bullets and had no idea what was going on. I think it necessarily implies other co-conspirators or others involved, which I think is where the true conspiracy is. but all this batshit crazy lunacy about exploding mics now lumps everyone together in the insane theories, much like,
Okay, and I have explained this before, but anybody that was co-conspirator going on with this situation will not be arrested and indicted or anything until after they get a conviction from Tyler Robinson. This is common in cases like this. We have used the example on this channel before, me and Based Boy Mom, who both followed this same exact case, which was Dan Mackle, Dan. There's this man that was murdered by basically his mother-in-law and his brother-in-law after the divorce from his wife, and because they didn't like that he was being a pain in the butt in the divorce process and wanted some custody of the kids and wouldn't let his wife move. And they wanted his wife and the grandkids to move to Southern Florida. And so they, paid a hitman. And so once the hitmen were found, the hitmen were arrested. They used people that were part of the conspiracy in trial to convict the hitman. Then they went to the next round of people. The woman that facilitated the information from the brother-in-law to the hitman and the payments and the communication and all that, they charged her. Then they went to the next person, which was the brother-in-law who met with and facilitated the payments. Then they did even, it's so crazy. So once they got a conviction on him, they did weird stuff. They did a bump. So before they arrested the brother, they did what's called a bump. So they walked up to the mother-in-law and was undercover and handed her a newspaper with a headline or whatever and said, "We know what you did for blah, 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 and that you guys are helping him in jail. And we want our cut too," basically. They're saying they're related to the guy, the hitman, one of the hitman guys. And so then she goes home and she calls her son, the brother-in-law, and is saying coded messages that clearly and he's like, "Oh, I don't know what you're talking about. Are you talking about the thing? Are you talking about, and she's like, "No, I'm not talking," so they get her. So they do the brother-in-law. Then with that information and other things, they get her. And that was just last year, I think. And so we're still thinking are they going to go after the wife? Is she next? And this crime happened in 2013. Okay. So the idea that if there is co-conspirators, that we would know about it at this moment, because they're definitely not going to tell anybody or let on to the conspirators, but they're not going to move down the line until they get the person who, Tyler Robinson. They have to get a conviction on him because they can't prove the blah, blah, blah of all these other people unless they prove that this step of the process. So this could happen in the future. You know what I mean? We don't know because they're not going to tell anyone, and they're not going to let the co-conspirators know either. So, because if we know, then the co-conspirators would know, right?
The nobody died at Sandy Hook insanity.
Well, correct. Indeed, my criticism early on of the Candace Owens school was when I look at possible false flags, and what are false flags? It means some other culprit has failed to be identified. It does not mean the event didn't happen. It does not mean or necessarily entail that the person accused wasn't involved, or even in this case, the trigger man. It means that the full explanation and causation of the event is not been fully disclosed, investigated, or observed or found. False flag literally was when the pirate ships would try to get close to another ship to seize the ship by raising a false flag of some allied country with that ship, so it didn't know it was really a pirate ship, and at the last second they would raise the Jolly Roger. So in this context, what was I'll give you just quickly my giveaway on that Candace had bad faith motivation on all this, and that her motivated reasoning will govern her all the way until the end. Aside from little giveaways, like when Candace is exploring whether Bridget Macron is a man, She just can't conclude that Bridget Macron is a man. No, Bridget Macron is a man, Emmanuel Macron's father, and engaged in incest with him. Right? She's got to go to the most asinine, absurd conclusion. For ego, people think it's for money. She's going to be broke as broke as broke can get. She's married into wealthy with the British royalty, so she'll be protected. But her own money will be gone for forever because she's going to get sued by everybody into oblivion because she's got no shot in hell of winning all these defamation cases she's going to be facing, because it's quite obvious how reckless she is with her sourcing, how reckless she is with her interpretations, how reckless she is with retractions when put on notice of lying. But the giveaway here to me that there should have been a reason to investigate alternative hypotheses as to the causation of this murder, and whether other people radicalized him, whether they aided and abetted him, whether they tried to cover up for him, whether they incentivized him, whether they aided and abetted people around him to help facilitate this occurring. I look at unusual security lapses. It's like I have a little false flag template. You look at a cui bono analysis, you look at a false flag analysis, and you look at cover-up analysis. And those are three of the big keys.
Cui bono means who benefits. So, and I uncovered in my Candace Owens series, like on the last one, I believe it was, that she was pulling, and this is most likely, this is not definitive, but most likely what I uncovered with the help of somebody else is that they were pulling those newspaper clipping articles from the online old newspaper sites. They were pulling those about Erica's family at the end of September is when they started pulling that stuff she used for that Bride of Charlie video. So that means that she was planning on doing that all the way back on the end of September.
As to whether or not we may have a false flag event. All three are present in the Charlie Kirk murder. So first you got cui bono, you got the trans ideology that is rooted, if you get back into it, into intelligence community activities, into think tank and NGO activities, trying as Manchurian candidate projects that go back almost a century. So you've got that aspect that would have a motivation to do this, and evidence of it occurring in this context with the radicalization almost overnight, within a year or less, of this otherwise normie kid from Utah. You also have the potential Israel lobby connection, because of the number one profiteer from the death of Charlie Kirk has been the advocates of the Likud wing of the Israel lobby to go into war in Iran. Then you've got a highly unusual security lapse, but it's not turning point. And by the way, on the cui bono analysis, the people who had no reason at all to see Charlie's death is the mother of his children, is the wife of his children, is his lifelong friends, is his closest friends, is everybody in Turning Point, whose organization is entirely and was and being proven to be very reliant, dependent on Charlie Kirk to survive and sustain itself. So cui bono says you rule out all the Turning Point people, you rule out Erica Kirk of the family, you rule in the possibility of the trans identity agenda of NGOs and think tanks connected to it, of intel communities running Manchurian candidate type projects through it, and of the Israel lobby. Then you go to the unusual security lapse. Is there an unusual security lapse? There sure as heck is, as was confirmed in this trial, which I got blowback from people pretending this wasn't true. It wasn't Turning Point security failure here. The failure was entirely on the university.
Well, some people will say it was Turning Point security failure because they should not rely on the university's assurances that they've got a roof covered if they don't have it covered. And so you could play that game. The
problem with that is they don't control the campus. So they legally could not compel the university to do it. And my understanding is so for those people that don't know, the university, Turning Point identified the rooftop as a risk point, wanted the rooftop secured. They wanted a drone over that rooftop. They wanted security present on that rooftop, and the door to access the rooftop to be locked. The university came back and said, no, you cannot put a drone up there. No, you cannot put security up there because we control that property and we don't allow drones there, and you don't have to worry about it because we are placing security there and we are locking that door. It is still unexplained to this day why the university lied.
Okay, so this is true, and this is something I have a question about, and not only me, but Bronson also has brought this up. Shout out to Bronson. But he has said several times, like, this is very weird. Why do we not have an answer as to why UVU did not have that security locked down. Like, they only brought 6 officers. They said they were going to secure that roof to Charlie's head of security, Dan Flood, and they didn't. No one, Candace completely stopped talking about that altogether. But no, we have never gotten an answer as to why that was the case, that it was such a lax security. And so I've always said, like, they could be sued by all those students that were traumatized. Like, they didn't properly, for an event like that with such a controversial person. Yeah, so the whole thing is suspicious along those lines as well.
They lied about the drone access. It was not within their legal rights to prohibit that drone. But by the way, they were still doing that months later, because other people tried to go up and put a drone up there. It was like, no, that's our airspace. No, it's not. But that's so maybe you could excuse that as a mistaken understanding of their legal authority. But what was not a mistaken understanding was why they had no security present and didn't even lock the door. So so you have an unusual security lapse. You got cui bono for other culprits. You got but not the culprits being identified by Candace Owens, notably. You've got the security lapse, and then third, you have the FBI refusing to investigate those particular leads into the trans NGO part. And when Joe Kent, based by the way.
Okay, we don't know if they refuse to investigate any of that part. They could be investigating all that part, because Joe Kent is not an investigatory branch of the government. Like, the role that he had was not an investigative role. So when he tried to say they wouldn't let us investigate, well, let you investigate what? You're not an investigative branch of the government. That would be, you hand over information to the FBI and they investigate, and you don't know what they have done or what they haven't done, because you're not purview to those things. So we don't know about that. I'm going to end this here. So if you want to hear the rest of it, you guys can watch Viva Fry's video and him and Barnes, and I will leave the link to the specific video in the description. But there's also, he interviewed Justin with Phoenix Ammunition before this interview, and so go check out his channel, because there's some good stuff on there. But this is getting long, and I am very tired, and I need to eat before I go to bed, because I haven't ate dinner yet. Okay, so I hope you guys enjoyed this episode. I tried to be thorough. I tried to kind of go through all of the stuff people have been talking about on all sides, and I just, eyes look weird. I don't know why my eyes look weird. They look weird on the camera. But I'm telling you, this camera is like crazy. Okay, anyway, I hope you guys enjoyed this episode. I tried to bring in all kinds of different ideas and takes, and what people are saying, what these people are saying, and just kind of do like a basic big overview for the week, just to have my reporting that I am doing on this case rounded off. I know that we've been getting information from everyone, but I just wanted to add my own flavor to the whole situation. So I hope you guys have a good rest of your day or evening, whatever time it is for you. Please like, comment, and subscribe. All the important links are in the description box below, and I will see you next time on The Eclectic Journalist.